myself.
There I am.
Yay!
Too many cooks in the kitchen.
Can you make us like more even?
I probably can, yeah.
Because you look so cute. You can be the biggest one.
No.
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 Well, my thought was kind of whoever is talking, I would
Oh,
expand.
okay. That's cool. I like that. Okay.
So that kind of gives us to, with 3-4 people, you start to get into the realm of who's answering the question and all that.
You know what would be cool as we get ourselves set up is if last time people were telling me where they were from, which I thought was super cool. So if you don't want to be specific, like put a flag or something or say the name of where you're from, because it's really cool to see so many people from all over the place.
Yeah, actually, if everyone could drop your specific address.
Don't do that. I don't want to see it.
Yeah.
This is a perfect setup for a joke that I'm not going to make because I get yelled at by the people, but you guys know what I'm saying.
Yeah. So we have Texas, Romania.
Wow. Saskatchewan.
Canada. Memphis.
London, Canada. I feel like we've got a lot of Canadians following this for sure.
I feel like we have a lot of Canadians and Brits and Aussies. I see a lot of Aussies comment.
Yeah. The like British Commonwealth. I love it. I guess
really
because,
interested.
I don't know. I love it. I'm dying to go to Australia. Has anybody been? I haven't been.
I've been to Sydney. I have an uncle that lives out there, so I've been to Sydney.
That's on my list.
That's fun.
Poland.
Some shout out to BB Well. Actually, you do look beautiful today. You all look beautiful today.
We're the glasses crew. Look at us, all 4 of us.
I know. I'm such a glasses lady.
Go ahead.
I tried to join the live, and I was like, apparently you can only do it on Windows for your computer. So I was like, I have to do it from my phone. And I got on the live and I was like, I can't see any. I tried.
I had like perfect vision all the way through like college and law school. I never needed glasses, whatever. And then a couple of years into practice, I went to an eye doctor and I was like, I can't read very much. And he's like, what do you do for a living? And I was like, I'm a lawyer. And he's like, oh yeah, you guys are my best customers. You and accountants. You guys can't see anything. Okay, well, it's because we read all day long, I guess.
We strain our eyes all day long.
All day long.
So do you guys want to start with kind of where we are in the case? Where are you guys thinking you want to begin? Does the comment have questions? Legal Mount Rushmore?
Oh, that's sweet.
Aww.
Oh, Legal Mount. I'm okay. I was like, Legal Mount Rushmore. Where's
You're looking at us.
this? Is it?
They're carving the mountain right now.
Oh my God. I will see myself out. Thank you all. Enjoy the live.
Thank you, Britt, for hosting us. We wanted to have a more smooth experience this time, and so far we are leaps and bounds ahead of where we were last time. So thank you. So this is really a chance for us to get together and answer questions and talk about some of the like hot items that have come out in the case recently. Last time we were talking about the MJOP that was filed, and there's been some rulings since then and some other things that have been unsealed. So do you guys, ladies, do you have somewhere you think we should start?
I posted this morning on the unsealed stuff, which I found to be super bleh.
Yeah.
There was nothing there. I'm very worried about this woman getting attacked and threatened by people. We need to not do that, everybody. Let's not do that. But yeah, I found it to be pretty nothing. Did you guys find the same?
Yeah. Go ahead, Bibi.
No, I was just going to say, yeah, I am not surprised. I think I saw you say, not actually Golden, that it made sense that it was unsealed because there wasn't much in there. And I agree.
Well, and it's not. I'm curious what you guys think about this, but it doesn't matter. You know, that declaration is not going to go. It's not going to do anything. So it seems like it was PR driven, probably, or mystery creating driven. But I don't see how the judge could even rely on that, even for the purposes of the 47.1 motion that they filed, because it's outside of what the judge would even look at for making an order on that motion, right? So with that, it doesn't matter. It actually doesn't matter what they said. It's not someone else coming forward and saying I was also sexually harassed. It's not someone coming forward and saying that I was defamed for making claims of sexual harassment. It's literally just to support the idea that other people didn't like him or didn't like being around him. And that doesn't really do anything legally. So I think even just talking about it more than we are now is probably like more than it needs.
Yeah, and I think people get confused, rightfully so, because we are not at a stage in the proceedings where you can utilize evidence that isn't already attached to the pleadings. Like for the judge to consider that, he would have to have an evidentiary hearing or something. It's not one of those things he can just take judicial notice of and say, oh, this is attached to the complaint, so it's fine. So I think he's just going to summarily disregard it, because if he allows that, then he would have to allow Wayfarer to submit evidence in opposition to it, because now we're going outside the pleadings. I mean, tell me if you guys disagree, but it seems to me that would open up a whole big Pandora's box.
Yeah. Yeah, it's I mean, we've talked about this, I think, ad nauseum, but just to reiterate, the judge, and at least my perspective, is not going to touch that motion until all is said and done here. And that's because there's bigger fish to fry in this case, with summary judgment motions coming up, a pending MJOP, legal claims that the sufficiency of which are being challenged. He's not going to sit there and rule on a sanctions motion that he wouldn't even be able to calculate what those penalties are at this stage. So it's a nothing. It's a distraction. And I think Wayfarer unsealing it is kind of like, okay, bet. Like, you know, we're going to show all our cards. That's what their whole MO or optics of their strategy has been from the beginning is, okay, you're going to put pieces of the cards on the table. We're going to put all the cards on the table. And, you know, the judge decided to dismiss Wayfarer's claims. That's a separate conversation. But it does track with the legal strategy, which is like, just lay it all out. What's the recording? The recording was done without Sorowitz's consent. Arguably illegal. Right. But they were like, fine, unseal it. Like, you already have it. You know, like, so.
I mean, BB, tell me what you think, because you're the one who has worked. I know, little girl attorney, you've also worked in judges' chambers. The one thing that does, like, because the extraterritoriality argument is being made in the MJOP, and that's also an issue in the sanctions motion, it seems like a more straightforward argument in the sanctions motion to say this is a very California-specific law and there's no reason for it to apply to things that didn't happen in California, because it doesn't have the contract choice of law language also included in it, where the other stuff does. So I don't know, is there like a world where he's working on the MJOP and he's like, while I'm at it, while I've drafted all this law about extraterritoriality, I might as well go ahead and, you know, if that's the grounds on which he denied this 47.1, is that reasonable?
I mean, potentially. I don't know that we're going to get a decision on sanctions anytime soon, because like the judge can just sit on it. And I like, my gut tells me that's what's going to happen. And then we're going to give ourselves some time to see what happens on the MGOP, because if we end up dismissing a lot of these claims on other grounds, then that's like a very easy, this is mooted now. And so I could see something like that happening. But I see what you're saying. I mean, potentially, but I'm not expecting a decision on sanctions anytime soon.
A lot of people are asking, like, why didn't Wayfarer ask to have it stricken from the docket? And I think that's a good entree into one of the things that we all said we were going to talk about, which is what you can do as a legal matter and what your strategy is. Because it seems to me that Wayfarer's strategy is like, why would we do that? Because he's probably not going to consider it anyway. So there's no reason to get everybody all in a kerfuffle about striking it. Do you guys read it the same way?
I think potentially. I think, something that I would fault Wayfarer for doing is not being as strategic in the past with the things that they're bringing to the judge. I think in the past there have been some missteps on the kinds of arguments and then also the kinds of issues that were like elevating to such a level. And of course it's escaping me now, but give me a second and I'll think of something specific. And so I do think that just letting this happen is the right call. Like, I don't think that Wayfarer, I think a lot of people are kind of noticing that the judge is not friendly to the Wayfarer side when they bring things, and so strategically deciding not to go for that strike, I think, was the right call.
Yeah, I in my practice, at least in my experience, I've really seen strikes used kind of in a very specific way, and I wonder if this case, like, I just don't. It's already out there. Like, the whole point is to say, like, judge, don't consider this. And it's usually for things that he could consider, right? And he's not going to consider it. So I think it would just be like an overkill filing to file a motion to strike. I don't know. And also, I think motion to strike, and I think people in the comments can maybe tell us how they view it. But to a non-lawyer, to a non-litigator, it sounds really like deadly, like strike, like my motion to strike, like like it just has this connotation around it. It has this kind of like vibe, for lack of a better word. And I wonder if they're also paying attention to that because, this case is so much PR driven.
I'm also trying to remember the standard. It's like, it's got to be something that's like the sole purpose is to embarrass, or I forget the specific language. And so there just might not have been an argument that they felt they could make there. But I saw someone just say, like, if they do move to strike, is it possible that the headlines then become Justin Baldoni's trying to silence another woman? And I think that we can't like lose track of both needing to track how the judge is going to perceive and how the judge is going to receive things, and then also how we all reading the headlines are going to receive it as it's being published and talked about in there.
And that's my read on why, at least partially why, they didn't file motions to dismiss in the beginning on some of these grounds that they are now using for the MJOP, because some of them obviously cross over because the standards are really similar. And my assumption is that they didn't want headlines that said, Wayfarer, Justin Baldoni gets out of sexual harassment on a technicality, and then, it looks like they're afraid of it. So, I mean, obviously we weren't in those rooms, but I imagine those conversations were, do you want to win the legal issues, or do you want people to know your side of the story? Because you can't have both. Does everybody see it that way?
Yeah, I think you're spot on. I mean, if they had moved to dismiss on the grounds that they had whatever months ago, then it would look like they're, like you said, they're getting out on a technicality. There's more to the story that we don't know, and now we don't get to hear it. And I think just by how the cross complaint or the counterclaims read and the amount of information that they put into the public sphere, that tells me that their strategy is, we want everyone to know everything. Because if we're going to defend these claims, these allegations, then we want people to see and come to their own conclusion about the case. And that's why they filed that crazy timeline. I've never seen anyone do anything like that, which like outlined all this stuff that arguably you can't like attach to a complaint. I don't know. I've never done it, but that's why discovery continued. They're like, all right, they filed it right at the end of fact discovery, meaning that there could be no optic or no headline that said you didn't even let her discover if there was more information, right? So there's no argument, at least from the PR argument. There's no PR argument to say she didn't have her chance to get all the information that she's entitled to when you make these claims. So I think it was strategic for them to do it. And I don't think and the judge, said, I'm not going to rule that it's untimely, because it's not untimely. They were entitled to file it when they filed it, but it was definitely strategic because they have to pay attention to how this is playing out in the public.
Yeah, I can see a conversation between Sarowitz and Friedman and Fritz and all the other lawyers saying, listen, we could get into this and it'll be expensive, right? You're going to have to pay us to do discovery and it's going to be time consuming and expensive. But if we do it, then all the information will be out there and no one can ever say otherwise. And if I were Steve Sarowitz and I had that kind of money, that might be really tempting to me to be like, okay, do the work then. He's got the money for it. But it does interest me. I wonder how much, like Jed Wallace, is the dark horse in this whole thing. Like, we don't know what his deal is. I wonder if they had a say in that discussion because he's really the only one who has tried to basically block every type of discovery that people want from him because his job is to be invisible.
On that note, I did get a question. You guys, I'm literally writing questions down.
Love you, Brit.
So I'm sorry I'm not keeping track of who's saying what. It's in the worst chicken scratch. But when do we think he'll rule on the Jed Wallace motion to dismiss? Do you guys have a sense of that? I feel like everything is sort of just whenever the judge feels like it. And a little bit of this, to me, feels like the judge's strategy of this case is very closely watched by a lot of the public, and he's really carefully trying to keep the timeline of the docket, under control and making sure everything is good for appeal. And BB, well, actually, this might be a good question for you, but do you have a sense of when you think he might?
I mean, I think that's the thing about federal court is like there's little teeth. And so judges really can can come out with their orders when they want. I think I did a video on this. There is that one report that comes out twice a year that shows how far behind judges are on different motions. And they really don't like to look bad on that. But like that's looking at 6 months out. So really, realistically, it's at the judge's discretion. And so, I could guess, but it would be just a wild guess.
Yeah. I did check the docket this morning just to make sure I wasn't going to get blindsided by anything today. And he did deny that motion of Wallace's to stay discovery, to stay the expert disclosures. And that to me looked like an indication he's about to dismiss him again.
And didn't he also kind of low-key promise Babcock in that hearing that it's something that he's working on? Like I remember some commentary by the judge that he's like aware that this has been pending for a while and that he's getting to it. He didn't say anything really beyond that, just kind of like a nod that like, yeah, I know this is pending and it needs to be resolved. But yeah, I think that's a good point, not actually, Olin, that's like, that might be an indication that things are coming down there.
And someone as a follow-up asked if Jed is dismissed from New York, is that Blake's last chance with him? I know Texas is still active, but New York. Yeah, so he'd still have his case pending in Texas.
Yeah.
So, she could bring her counterclaims there. I don't think the Texas law is going to be particularly favorable, but that's probably more for the employment attorneys to be answering.
Yeah, I mean, I haven't even thought about if she were to pursue claims against him in Texas. I think she really wants them to be in New York, and I don't know if the juice is worth the squeeze for them to do it. It does seem like they have set fire everywhere, but there have been critical points where the Lively team finally decided like it's not worth it. Like the Perez Hilton stuff, I think was an indication that, this is where we're not going to go. Like the minute the ACLU stepped in to represent Hilton in that subpoena drama, they were like, okay, withdrawn, we don't care anymore. But you still, I think, have Popcorn Planet fighting with them in Florida over it. If I haven't checked that docket in a minute, but
There's a hearing on that. I want to say the 28th. I have it calendared for later this month, so that's still upcoming.
yeah, so there are touch points, there are sensitivities that the minute it gets to that point for the Lively legal team, at least, when we say Lively, by the way, I think BB, well, you said this in one of your videos, but when we say Lively or Wayfarer, we're talking about the lawyers. You know, there is like obviously a lot of correspondence with the clients and their lawyers, but a lot of this stuff is driven by the lawyers. And yes, they have to sign off on decisions from their clients. Like they have to tell them we're going to do this thing and explain what it is and why they're going to do it. But you don't have like Blake Lively sitting there being like, go do this. Now there could be, but like for the most part, this minutia stuff, that's all like driven by the lawyers.
It's interesting to like watch that part of it. And I was thinking about this with the Drake situation too, because of Michael Gottlieb, but like how different lawyers deal with different, you know, some lawyers are like, you want to go balls to the wall? Let's go. I'll do that for $1,100 an hour. What do you want to do? You want to go? And I think a lot of clients think like, yes, let's be zealous. Let's be right. Like that's what they want from litigation. But that's not always going to get you the outcome that you want. And I think that is one place where Wayfarer has done a better job of being like, let's not. Now they filed that big, you know, complaint and it all got dismissed and they had to take a huge L there. Now, I don't know if that was part of their plan, that they knew that was possible, but they just wanted the information out. But in terms of like going after Lively's claims, I think they've done a better job of stepping back and being like, let's wait until we actually think we have a chance of getting something instead of just putting stuff on the docket just to put it on there.
Yeah, I agree. I think that they can't deny the tenor of the position that they're in. And we touched on this a little bit earlier. So to fight certain things could give the perception that, you know, Justin Baldoni is silencing women, even though it would be a totally viable thing from a legal perspective. That's what mainstream media is going to plaster all over the internet. And so they have to be careful about how. Now, in most cases, that's not really a consideration because you're not constantly worried about how the headlines are going to spin it, and it's not reputationally damaging in the same way. So even if like company X is suing company Y and like their reputation as a company is being implicated, it's not like your character as a human being is being implicated internationally. And so I sometimes like, I definitely don't envy the lawyers on either side, but I think about like, you know, in litigation, you're always thinking a few steps ahead. How is this going to go into that? It's going to go into that. But they have to do another added layer of like PR analysis.
Totally.
And thinking like, how is this headline going to play out when it's not something we can control? Totally. And that to me is the most fascinating part about this.
Totally. Yeah. I mean, what's kind of funny is that so many of these types of cases, they are kicked out on dispositive motions because of these technicalities. Like that is how you get rid of these types of cases. And I think that there was a worry. I think you're right on that there was a worry about coming out strong with these arguments before there had been enough work to create their narrative or their counter narrative. And I think it's safer to do that now. For sure, from a public relations standpoint.
I want to ask BB Well a question, maybe because I think a lot of people could really benefit from hearing this. So, as a former clerk, maybe you could give people a window into what it actually looks like to receive motions. Because I think what I'm picking up from reading people's comments is their perception that something gets unsealed. Well, why isn't the judge considering this? And like, how does the judge feel about this? Or how is this going to play into their decision on this other thing? And like, for example, the contract, like it got unsealed and like, well, how is he going to look at this when he rules on the MGOP? Well, wait, hold on. And so maybe you could give, I think it would be helpful for people to know, A, like just how many cases a federal judge has how many clerks work on those cases, and how you parse through what you work on and how you do it. I mean, I know that's a lot, but I think it would be incredibly helpful for people to hear.
I can take it bite by bite. So federal judges have a lot of cases. SDNY is one of the busiest jurisdictions in our country. I did a video on this, and it was in the hundreds. I cannot remember exactly the number. I will pull up those facts and maybe do another revisit video. But the important thing to note about federal versus state court differences, in a lot of state courts, judges are given a rotation, and so they might just be on family law for a period of time. They might just be on a criminal circuit for a period of time. Federal judges have both. They have criminal law cases, they have civil law cases, and they're hearing both at the same time. And in the United States, we have a constitutional right to a speedy trial. And there is the Speedy Trial Act, I think is the name of the law, which gives very specific deadlines and kind of codifies our constitutional rights on how quickly these things need to happen from a criminal standpoint. That doesn't exist from a civil standpoint. The number of times that I've been a clerk and trials, hearings, decisions got kicked because we got something that we needed to do and take care of on the criminal side was pretty regular. And so I think that's kind of an important layer of context to this. It's not that civil cases are less important. There's just your personal liberty isn't at stake with a loss in a civil case. You might lose some money, you might lose a little bit of your reputation, but you're not going to jail. You're going to prison. So that's one consideration. I'm blanking on the rest of the questions. Can you remind me?
Yeah, sorry, I threw a lot at you. But that's actually really, really important, I think, is for people to get a context of how there's so many cases and what takes priority. But maybe you could talk a little bit about when a motion comes in, let's say a motion to dismiss. How does that
So I clerked with I've worked in two different federal district court chambers, and they both had similarities. And basically what happens in my experience is that the judge will assign you a case, and that's kind of your case for the time that you're a clerk. And so you're responsible of keeping track of the docket, making sure when things get filed, you're on it, you're reading it. If there's something urgent, you're one of the people that needs to raise that it's urgent with the judge. And then each federal district court judge gets 3 clerks. Unless they're the chief judge, then they get 4 clerks. And traditionally, they're recent law school graduates. So they're people who have just graduated from law school and don't have a ton of legal experience. They tend to be towards the top of their class, but they're junior attorneys. You can also some chambers have a career clerk. That's someone who's a more established lawyer, and their job is to just be a judicial law clerk. That's their legal job. That's always really helpful because then, as a clerk, you have someone you can go to who has a wealth of experience, and you're not always bothering your judge. But yeah, if something comes in, and then as a clerk, I had anywhere between 30 to 50 cases that I was assigned at a time. And each case was kind of in a different phase of litigation, and so it kind of depended. And, when you get a motion to dismiss, you have the whole record that has been built. And I've gotten some motion dismisses that were transferred from other jurisdictions, and so they had a little bit more because it was coming in from somewhere else. But when you get a certain type of motion, like a motion to dismiss, a motion for judgment on the pleadings, you're bound by what you as the court can look at. And so it's not just because somewhere else on the docket there's been something filed, it's not necessarily true that the judge and the clerks are looking at that when they're making their decisions. Does that sort of get at the question? Is that what you're looking for?
I'm getting some questions too on just how it looks. Are clerks always lawyers? If an appeal goes through, does another clerk take the case? So kind of talking about the structure of what a clerk is and what that means might help.
Can I just jump in and say one thing, because it's so basic that Bibi's not going to think of it because she's up here. I think, and I just noticed it because I've never thought of it. There are law clerks that work for the judge, and then there's the clerk of court.
I had to explain
Yes.
someone to that in comments earlier.
Okay,
Thank you for doing
explain
that.
because
Yeah.
I'm just thinking like we keep saying clerk.
Yes.
Like the clerk of the, okay, so anyway, go ahead.
No, you take it away. But yeah, those two are very different. Yes.
Yeah, the clerk of court is an administrative role where that person is the person responsible for everything that gets filed, administered, how cases get assigned. That is like the manager of the court. Whereas court law clerks for individual judges are lawyers or law students.
And
Yes.
correct me if I'm wrong, but the clerk of the court doesn't have to be a lawyer,
No.
right?
No.
Clerks for judges do.
Yeah.
Yes.
And
yes.
as BB was saying, there's the clerks that are freshly graduated, top of their class law school graduates. And then there's career law clerks that are assigned to a judge. Like when I was working at the California Supreme Court, the Chief Justice had, I think it was 5 career law clerks that worked for her and worked for previous chief justices. They just stay. They worked for the court. They're there forever. They're like amazing. And that is their job forever and ever. Like Ninth Circuit also has that, like career law clerks that their entire career is working for the justices or judges. And then there's this, like, it's 2 years usually, right, BB? Like the clerkships that you get after law school are 1 to 2 years, right?
1 to 2, yep. Yeah. That's an important distinction. But yeah, so as a judicial law clerk, you are typically assigned to one judge, and that is kind of your rotation for the 1 or 2 years that you're a clerk.
And
Go ahead.
did you feel that your opinions influence the judge, your input influence the judge? What did it look like? Do you just talk about it in chambers over this one motion? Are you going to lunch and talking about it? Like, kind of walk us through that as well.
Like,
Yeah,
did you
so-
ever say, I don't like this person, so I don't want to rule in favor of them?
I mean, y'all kind of know me, so that's not me. That's not me. I'm not like talking about, I don't like this person. But certainly you as a clerk do have influence, but I don't want to overstate the level of influence because to get to federal district court judge, you have to be at the top of your game for a very long time. And then you have to be nominated. And then you have to be like, it is a very strenuous process. And so I think it would just be kind of ludicrous for me to think as a recent college graduate, I'm, the decider and the decision maker. That wasn't the case, but you do have influence. And I can think about a few times where my judge saw things one way, I saw it another way, and after conversation, we ended up in a different place. And so, yeah, you absolutely do have influence, but you're bound by the law. And I say this as someone who can feel skeptical about the law. It's not like the law is the law, because you certainly can argue a lot of different sides of any issue. But I think that within the boundaries of what is permissible, yes, you can have influence, but you can't make stuff up, obviously.
And you can even argue that the law shouldn't be the law at all. Actually, this is unconstitutional.
Totally.
Yeah.
As long as you have, a non-frivolous argument for extending the law in a way that it doesn't exist now, you can argue that it should be something different, theoretically.
Yeah. Somebody asked, and I know the answer, but I think it's worth the chat to hear, but who do we think the ultimate winner will be? And we're before motion for summary judgment, but I also think there's kind of a sub question to that question, which is there's the PR winner and then there's the legal winner, right? And so I'd love to hear your guys' opinions on that. And BB, well, actually, you're already highlighted, so tee us off, babe.
I think that both likely are losers in the PR's arena. I think that there are people who are going to support either of them regardless, or kind of like feel very strongly about one side of the case or the other. But to the general public, I think both sides have taken a hit to their personal brands. Legally, I think that just going on statistics, it is really hard to win this kind of case as a plaintiff. So if I were just statistically speaking, based off of what I've seen so far, which isn't everything and not enough in some regards, I would say that the Baldoni side, statistically speaking, is in a stronger position on this type of lawsuit.
Yeah. Little girl attorney, what do you think?
Yeah, I mean, to Bibi's point, there's so much we haven't seen. I mean, there's a lot of discovery that's been fought over, so we've seen pieces of it. Like, there's like parts of deposition transcripts that just came out the other day, and I was looking at them. I'm like, what? Who cares? Like, this is so uninteresting, and it doesn't give any information. But there's like pages and pages of deposition transcript that we haven't seen, right? And there's documents, apparently thousands and tens of thousands of documents have been exchanged by the parties that we haven't seen. So there's still so much, but I think from a legal perspective, because I'm looking at it from the lens of an employment lawyer, an employment case, a lot of these under California employment law, and like to how do these play out? And, I think there are claims that are stronger than others. And for example, I'll say that it is very, very, very hard for a defendant, an employer, or a manager that's being sued for sexual harassment to prevail at motion for summary judgment. It's almost impossible because ultimately the plaintiff is going to say, this thing that you did made me uncomfortable. And the other side is going to say, or they're going to say it made the workplace hostile. And that other side is going to say, well, I didn't mean it that way, and also nobody else felt uncomfortable. So therein you have a issue of fact. And when there is an issue of fact, as simple as that, boom, goes to trial. No summary judgment. And so because of that, I think like, it's going to come down to a jury. Like, we're doing all this talk and all these fighting, and like people are really zeroed in on the judge and zeroed in on the law, but ultimately it's going to be 12 people that decide whether it arises to the legal standard that's going to be laid out in instructions to them.
Yeah.
So I think it's really hard to predict how 12 people are going to rule on something. You just don't know what they're going to care more about.
Not actually Golden. Give us your take
Well,
us home, babe.
I think, yeah, I'll wrap it up. I agree with little girl attorney. I think she and I both, as employment lawyers, like this is what we do all day long, right? We see a complaint or we see an internal report and we look at it and we just calculate in our minds, is this a slam dunk for one side or the other, right? So we looked at this on day one and we're like, okay, that's not obviously severe and pervasive. I can imagine how there might be some other evidence out there. I do see issues with connecting the adverse employment action back to a complaint because of the time. But also, like you said, we wouldn't be very good at our jobs if we looked at a complaint. We're like, oh, I know what's going to happen. You always have to assume that there's stuff you haven't seen. Even when it's your client, you have to assume there's stuff you haven't seen.
Yeah.
So I think we both kind of are like, okay, this looks like it is not a slam dunk sexual harassment case by any stretch of the imagination. I will say on the summary judgment part and even the MJOP, a lot of people are asking like why they put those appellate lawyers on the docket. And we haven't actually seen their names on anything yet. But you don't need to put appellate lawyers on a trial court docket if they're going to handle an appeal. They can just appear on the appellate court docket. So I'm starting to think more and more that those people are there to help them draft these dispositive motions, right? Because appellate lawyers are experts on what is a legal issue.
Yeah.
And if you're trying to avoid trial, you want everything to look like a legal issue.
Right.
So that's my guess, is that that's why that MJOP was kind of like straight and to the point, like bing, bang, boom. That's my guess. And I think they are hoping that because Judge Lyman was not afraid to grant a dispositive motion against Wayfarer, that he won't be afraid to do it for them. But that's just my read. Feel free to disagree.
Yeah. I have to second that. I think they came in to make sure that I don't think the only way you can prepare for an appeal is if your case is done buttoned up right before you ever get to the point where you have to appeal. Right? Like they don't really have something to do because there's nothing to appeal right now, but they're making sure that if it gets to the point where they have something to appeal on, that they have preserved their record in a pristine way so they can say this falls outside of the court's discretion. It falls outside of what the law prescribes, which is I think what you're saying about legal issues. And that's the part that the appellate court is going to be most concerned about. Not necessarily because there are so many situations where people don't like a ruling and then they appeal it and the appeals court says, well, that was within the court's discretion to decide that thing in that way. And
Hey,
boop,
Drake.
back. Yeah.
And the appellate courts are so deferential about fact findings to the trial court, and so that is how you get an appeal, is that you really hone in on wrong decisions made on the law. And so yeah, I completely agree. I wanted to clarify my point on my statistical point. I don't mean on the motion for summary judgment. I don't think anything's going completely away after motion for summary judgment or motion for judgment on the pleadings. But in terms of what I think might happen at a trial, who knows? But I could see it being an uphill battle for Lively.
Okay, Son, I know I said I'd ask your question next, but I'm getting a lot of questions on Blake's motion for summary judgment, which kind of tails into this. And how do we think that, that would help her? What are our thoughts on her filing a motion for summary judgment?
Well, I'm curious, not actually Golden and Little Girl Attorney, whether you think there's like a tactical disadvantage. Because I know she'll be wasting money more likely than not. But like, is there a tactical disadvantage to like showing her cards in a way by doing this? What do you think?
I will just say I've never seen that go well. I mean, I've never, first of all, I don't see that a lot in these type of cases. I'm like literally trying to think of it. Have I ever seen a plaintiff claiming SH or retaliation file? So I don't think I've ever seen one. And I've been sitting with this because they said this on that hearing, and I wonder if it was just saying it for the sake of an argument rather than actually saying that they want to do because you want to go to trial. That's why you brought your case. You want to show that you win based off of the facts. Like, I don't know. I mean, not actually Golden. I'm curious what your thoughts are.
Yeah, I'm the same. Like, I think we're all like gaming out. I mean, she would have to file her summary judgment motion for different claims than the ones that Wayfarer was going to file summary judgment for. Because when you oppose summary judgment, you're saying that there's fact issues. So you're not going to file one motion that says there's no fact issues and then respond to another saying that there are, right? But I think the only thing I've seen that makes sense is she gets to attach a bunch of evidence to the motion and be like, here's all the evidence I have. I don't know, maybe she could do it on like the breach of contract claims.
I think maybe the affirmative defenses that's the only thing I can come up with. Because Wayfair has to affirmatively prove specific defenses, and I don't think I've made a video really going into what that is or what that means, but that is the only thing that I can think of that they would specifically move for summary judgment to say like you don't get to have that defense because you have to prove that defense and you're incapable of proving that defense. There's no issue of fact about your defense, and so you don't get that defense. Like that's the only thing I can think of. But like with respect to her own claims, like that would not be a smart move, I don't think.
Yeah.
Yeah, that's the smartest thing. That's the smartest answer to that question. I think that would make the most sense. I just want to say I'm seeing a lot of people talking about like, why wouldn't you take it to trial? And I get this question a lot. I'm sure we all do. And we could go on for 2 hours about this, but even if money is no object, right? Like a lot of times you don't want to go to trial because it's expensive, right? But obviously money is not a problem here. No matter how good your case is and no matter what evidence you have, trial is a risk. A jury trial is a risk because as Little Girl Attorney said earlier, you never know what a jury is going to do. And so even if you think you have the best case known to mankind, what if somebody has an off day that's a key witness, or you just don't know what could happen? And so it's always on the table. I think I've never been in a case where it wasn't legitimately on the table, including cases that went to trial where it's like, let's for real earnestly discuss what the risks are to that. Because you have to get really real with clients and be like, we could go in there with a 99% chance and lose. And I assume those conversations are happening here.
Yeah. I mean, I do 99.9% of my cases are bench trials, and I still feel like it's a gamble. I mean, I tell clients all the time, I practice in front of this judge all the time. I cannot tell you what they're going to do. So, I mean, once you get 12 strangers in the mix, it's like going to Vegas and being like, I don't know, betting on red. Okay, what about the indemnification? What do we think Stephanie Jones and Blake Lively are going to do now that she's lost on the indemnification issue?
It is hairy. I don't think they thought that this Uno reverse was going to happen. I mean,
Yeah.
it's essentially like, honestly, I don't know how they didn't anticipate this because employers indemnify their employees all the time and former employees all the time. So, Lively suing one of Jones Works' former employees for things that happened during her employment. They should have anticipated that Abel's going to be like, hold on, like you have to indemnify me for defending this lawsuit. But there's this whole other piece, which is that, oh, look at my crown. The there's this whole other piece where Jones Works, is it Jones Works or Jones herself, is suing Abel.
Yeah.
And so, because of that, the indemnification isn't going to play out how it typically plays out, which is the employer goes and says, okay, I'm taking over defense and I'm going to do I'm going to make sure that you're defended in this because ultimately, like, it's our responsibility to do so. They're not going to do that because they're suing them. So I don't know. I haven't like thought about exactly how this could play out, but I think that Jones is in a very, very precarious position now. And now is realizing like, shoot, I'm out. I'm like hung out to dry at this point. Like I'm damned if I do and I'm damned if I don't.
Yeah. Hot Mess Mama Bear asks, doesn't Abel have to prove she did it under Jones's direction? Why don't, not actually Golden, since you're our resident professora, talk a little bit about how indemnification works.
Okay. So I'm not going to say the ID phrase, but the facts matter. I have a deal with my clients, by the way, that I say, if I ever tell you, it depends, you can tell me, you can like call me out on it because I hate it when people do that, but it does. With indemnification, it's all going to run on what the indemnification clause says. So when you're talking about things at someone's direction, you're talking about like the agency principles of like the principal agent, was she acting on behalf of Jones Works? And that probably does come into it a little bit, but I think it's more likely that it's going to be, what does the indemnification clause say? And if I remember correctly, it says something like Jones Works will indemnify you for, disputes that arise out of this employment agreement or something like that. So that doesn't necessarily give her a threshold that she has to show that she did it at Jones's direction. She just has to show that it was within her employment. Now, obviously, there's this really funny time when she's still working for Jones, but she's talking to Melissa Nathan and she's technically still Jones's employee, but she's setting up her own shop, which could be a fact issue. But no, I don't think she has to prove that she was acting at Jones's direction. I think the double whammy for Jones this week was not only that, but also then the motion to dismiss getting denied in the other case that Little Girl Attorney was saying, that Jen Abel's like computer liability claims get to go to the next stage, because that could be a lot of liability for Stephanie Jones. And not to mention the fact, oh, thanks. This is one of the things that I am still baffled by, why she hasn't tried to settle herself out of this. Because I understood when she filed the original case, because she's like, okay, I've got to enforce my agreement to show my clients that when they sign an agreement with me, I fucking mean it. And if you break it, I'm going to enforce it. Like, I get that as a business person. But all of these allegations about the stuff that she did and giving the information out and taking Abel's phone, the longer they go on, the less and less I would think anybody would ever want to work for her or work with her. And I just don't understand why does she really think she's going to somehow get the slate wiped clean? Because I kind of feel like she lost the PR battle a long time ago. How about you guys?
Yeah.
I've talked a lot, so I'm gonna let BB talk.
Yeah, PB will actually. I want to hear your point, but I was just gonna say, I I feel like that case is more likely to settle because they have a lot of reputational issues that just aren't going to be solved by going to trial. I think it's this sort of subplot, and I think they're much more likely to settle because people are less interested in that, and they have much more to gain by settling that case. But I want to hear what you have to say.
Yeah, I mean, that makes sense. I don't have much else to say other than the only time that I've seen this indemnification thing come into play has been like insurance claims when the parties have like much more of aligned interests. And it's so interesting to me how that'll play out here because they are not on the same team. But they're kind of arguably, might be required to be. So we'll see what happens with that.
Yeah, I
It's,
think they have to make a business call. Like if I was advising a business that, these claims are going forward and you're every day and it's ironic that she's a reputation firm. She's a reputation company. Her reputation matters if she's representing other people. And so at some point it would be like, look, this is not even a legal thing anymore. This is like you need to make a business decision about whether or not this is worth your while to pursue these claims and to have to defend the other ones. Why don't you find a way? And so that's why I wonder what are the back end conversations that are happening? Because remember, Jones was not named in Lively's complaint. Jones or Lively doesn't have any legal beef with
Hmm.
Jones, which suggests that there is some like low level of cooperation between the sides, or at least alignment of interests. And
I
now
think.
that is being frayed, that like
Mhm.
alignment is being frayed. And so I wonder what those conversations are like hold on, now I'm gonna have to pay if you sue Abel and you prevail and there's all these damages, I'm gonna have to pay. Like, I don't think so. At least that's what I would be saying.
you
Yeah,
think
I've had that conversation with clients before, especially plaintiff clients, where you kind of have to sit them. It's almost like a therapy session where you have to be like, your desire for revenge is keeping you from thinking logically. And you might be pushing forward expecting a result. Like, what if you never get it? Will all of this have been worth it? And that's my guess, is like you just said. I think those are the conversations she's probably having with her lawyer. She seems like a nightmare of a client, to be honest. I mean, just
Yeah.
because of the and I don't know her personally, but just because of the arguments she makes and the way she handled all this, I would not. I think she's one of those who's like, I want it. I want revenge against these people. I'm upset about this, and I just don't think that's the other thing too. Is, and I've tried to say this before, but like, the legal system cannot solve all problems,
Yes.
right? Some
Exactly.
things courts can't solve.
yeah.
And like someone needs to, I'm sure they've tried to tell Stephanie Jones, like, the problems you have, no order, no judgment in the world is going to solve. You need to like, let's focus. But of course they're getting paid by the hour. So, cuts both ways.
Don't
And that's
forget, there's the New York Times. Don't forget that the New York Times is also is intertwined with Stephanie Jones and potentially Van Zandt and the documents and how that played into the article coming out. And so there's so many layers of alignment in different places that are now starting to be tested based off of how the judge is ruling in these cases that just makes it so much more difficult for these parties to be as aligned as they at least could have been at the outset of this case. Because now the New York Times is coming and being like, we should have never been sued. We're suing you for having sued us. And, you know, they have a vested interest in doing that. And maybe Jones feels like, well, the New York Times is suing them. So like if they win, then I'm protected because blah blah because that all is connected in some way. So I haven't actually like fully I'm not really prepared to talk about the New York Times case because I read it very briefly like a week ago when it came out, but just from like a zoomed out perspective, these things all kind of play into each other.
Yeah. So tailing into that, from the outset, do you feel like Blake's, just from your perception, do you feel like Blake's goal was to bring this to trial? And is there anything you see that she should have done differently just from the outset from that CRD complaint? BB Whale
Oh
actually is
man.
giving us some nods.
Yeah.
I think that if I were advising Blake Lively with the benefit of, hindsight, like with the benefit of knowing what I know now, I think that I would have wanted her to not go public. I would not have done the New York Times piece. I would have said, let's focus on the law. Maybe give like one interview where it very much focuses and centers her as a victim, but not. I guess so much of what I have read and seen has been like a focus on Justin's character and what Justin did wrong, and much less focus on like protections, workplace protections, what happened to her in the workplace, what happens to women. Like I would have centered around that story rather than taking down Justin. And I don't know if that's her intention, if that's had been her intention in some of her communication strategy, but I don't think that it's been effective. And so I would have either had her say a lot less and just focus on winning in court, or completely rethink how we're framing this conversation and focus more on workplace protections and what happens to women like her in workplaces too often, and not on how terrible Justin Baldoni is and how terrible he was to her.
Yeah. I think the point you made about, really educating her on what happens to women in these cases is a big one. We don't know what was going on behind the scenes, but women aren't believed. And so if you come out, you have to come out with a ton of credible allegations that can't be easily disproven with context, right? That can't be, oh, he was calling me sexy. And then you find out she has messages calling everybody sexy, right? Like that can't be how you frame things. I'm not saying she didn't feel uncomfortable, but, to your point, people will dissect every little thing that you did and see if you were asking for it.
Well, I think my suspicion is that they never expected this case to get to where it is, just based off of how it's been litigated. Like, I think that the New York Times was the article was very damning and caused a lot of damage to Wayfarer Justin's image, reputation, and was able to explain to the public why she was receiving so much hatred, vitriol, whatever you want to call it, online during leading up to the premiere of It Ends With Us. So I think that that's what it was intended to accomplish, was explaining why she was in like such a harsh light in front of the public, right? Reclaiming the narrative. But if Bocce's on, maybe she's like a human encyclopedia, remembers things that I cannot remember. But my memory is that it was actually Wayfarer that sued first in LA. It was actually Wayfair who sued them, saying you're defaming me by the New York Times article and what you're saying, et cetera, et cetera. And then Lively turned around and sued Wayfair and all of them because it was a reaction to the lawsuit, and they raised all these issues of litigation privilege, reporters privilege, blah 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 privilege, and that's how they were able to prevail on that. But it was actually in reaction to a lawsuit that was brought against them, challenging them for destroying Wayfarer and Justin's reputation. So I don't actually think there was a real intent. And obviously, I don't know. This is just me like speculating based off of nothing. But because of the way that the litigation has played out, they could have filed a CRD complaint and let the California Civil Rights Department investigate it. They could have done that, but they didn't want it to be done privately. They wanted it to be done publicly, and they wanted to be done publicly in their narrative, which is why they went to the New York Times instead of file a lawsuit first. Had she just taken her CRD right to sue and said, you know what? No, everyone needs to know that women are being harmed in the workplace, and so we're going to sue, that would have tracked for me. But because they went to the New York Times first, it tells me it's more about reputation than it is about law and about advocacy. And it was only done after Wayfarer was like, you're defaming me by these allegations that you put in the New York Times. That's just my kind of 2 cents. It's not really based off of like facts. It's just how I perceive this.
Well, it's based on your expertise in doing this all the time, right? So
That
it is
too.
based on something.
I think we all, as lawyers, very much see that the New York Times article, an article in the news, much less the New York Times, much less Megan Twohey, is the difference between this case and a regular case. Even more so than the fact that these are famous people, that's what makes it different. And I know that a lot of people have talked, and I think they're mostly right, about maybe the cascade of how this happened, that the New York Times said, we need to have the fair report privilege, so you're going to need to file some kind of legal complaint if you want us to talk about this so that we don't put ourselves in a nasty spot. But they, to your point, little girl attorney, they could have done the CRD process. That would have counted, but it still would have all been public because it was in the New York Times. I have had a theory, and I don't have any idea whether this is true, and I probably never will. But, it's fun to have those theories. That, and I'm not in any way, shape, or form, this will end up on Reddit on some pro Blake Reddit thread, right?
All
that
of us
I
do.
Blake made the whole thing up. I'm not saying I think she made the whole thing up. I think she believes that these things happened. I'm not sure she's correct about what those things meant in context or whether they reached the level of sexual harassment under the law. But I believe that she believes that these things happened. But I also think that the fact that she had this New York Times article come out about how she was really being hurt as a woman, and that she was bringing a claim of sexual harassment as a woman, I don't think it's a coincidence that it happened at a time when everyone was really upset with her because of the way that she handled the domestic violence themes in the movie. And again, I'm not saying she filed a frivolous claim, but I think from a PR perspective, it would make sense to me if they were like, we are losing female supporters between the ages of 22 and 50, and we have got to find a way to get these people back, and maybe we can kill a bunch of birds with one stone. You know what I mean? I don't think there's any ill intent there, but I think probably part of the reason for going to the New York Times was not only, I know people think like she just wanted to punish Wayfarer, she wanted to punish Justin. Maybe she also wanted to restore a little bit of feminist PR for herself. And she thought that was a good mechanism to do it. I don't think it worked, but I think it's not out of the realm of possibility that it was a consideration.
Yeah. So do you think they'll, I'm getting a lot of questions about appeal. Do you think Wayfarer are going to appeal with these attorneys to kind of shift from beginning to right now? Is that?
Depends on how it ends.
Yeah, I mean,
Yeah, I don't know. I don't know what we would appeal. Maybe, yeah, maybe.
Yeah, Nag always ends up on Reddit anyway, so. And just for the record, I like to go through on Reddit and like everything that's hyping you guys up. So when people are like, "Oh my god, I love this attorney," I'm out there liking it. So
oh my gosh, I try to avoid. I try to avoid it because it just stresses me out.
Yeah. Um, let's talk about our favorite Brian Friedman. He's got a malpractice claim apparently over a widower. I hadn't heard of this, but do you guys think that affects this case in any way? And if so, how?
It shouldn't. I think to be fair, I haven't read it. I haven't read
I
the
have no idea what we're
complaint.
talking about. I'm going to be honest.
Oh.
Yeah.
No one
So-
can find the actual complaint, right?
Oh, so okay, so it's not even out there because I'm like, I haven't even seen it. I've only seen headlines.
Chat
Okay.
was the first to let me know. So
Lauren from Court of Random Opinion was trying to find it, but it's behind that California paywall. Maybe, Little Girl Attorney, you can get it. But apparently it's a claim by the widow of the Travis Flores estate, claiming that Friedman committed, because unfortunately he passed away, claiming that he committed malpractice when he was representing the Flores about the movie, the 3 Feet Apart movie. And then he met with Baldoni and he decided to drop Flores and represent Baldoni instead because he realized these are the people I like. These are the people I want to do business with. And they're real pissed about that. Now, the switching from one client to another, I don't know about y'all, but I don't see it. I did read one article that said she claims that he shared attorney-client information with Wayfarer or Baldoni or something. That's all I know.
okay, so it's from the settled case, and then she's claiming malpractice because he's turning around and representing someone he brought a case against.
But he's allowed to do that. He's allowed to do that just because he represented the other side. I mean, it's actually like one of those age-old things that they said. Like the biggest compliment is for your opponent to turn around and hire you as a lawyer.
Yeah.
Like that's like one of the biggest compliments you can receive is that you are so good opposing them that they then later went and hired you. So I don't think that is anything in and of itself. And I don't know what the malpractice is. And malpractice would require them to say that like Friedman didn't get the most ideal result because of some kind of conflict that he had or some kind of malintention that he had. I mean, just on its face, it just seems very out there because we're talking about a case that's settled, and then we're talking about a significant amount of time before Friedman turned around and represented Baldoni in other respects, like not even in the same situation, not even against the same party. So I don't think anyways, that is something that we'd have to read to really like opine on. But your question was, how does it play into this case? It has nothing to do with this case. Like him being sued for malpractice by a former client should have no bearing on what happens in this case. Now, maybe his own clients are like, "Oh, do we want a lawyer that's being sued for malpractice?" That's their prerogative to decide if they want to continue with a lawyer that is being questioned for his representation. But that's a question for Wayfair. I don't think it has any real impact on the like existing litigation.
The impact I could see is that there's a motion for sanctions or attorney's fees coming down the pipeline, and sorry, I had to. Yeah, no, and for everyone, if you're curious, conflicts aren't just I represented a client, so now I'm their attorney forever, right? A conflict comes up when it's kind of the same nucleus of facts. So if I represent a party in a divorce is a good example, right? I can't then turn around and represent the opposite party in like a modification of their parenting plan down the line, right? Because it's the same kind of nucleus of facts, right? But if you have somebody in one case suing over copyright infringement and then later on the other person hires you for something, that's not a conflict. Now, as not actually Golden pointed out, if he's sharing confidential information from that prior case, you get into some trouble there. But beyond that, there's no real conflict there. Okay, the Claire Ayub. Sorry, Claire.
As if she's here.
Nothing.
Yikes.
Yeah. Look, girl, we are not here to bully you. We do not condone that.
No.
We said at the outset that was kind of a nothing burger. I want you guys to kind of go into Why it's a nothing burger. Maybe we could talk about some character evidence, because I've had people ask me about that privately. Like, why wouldn't you be allowed to bring that in? That kind of stuff seems like it comes in into criminal trials, right? So, do you guys have thoughts on character evidence or 607, 608?
I
Not
mean, if
actually
we're,
Golden speaking.
yeah, go ahead. Not, do you want to take this one? Not actually Golden.
I was gonna say you're the big square. You do it.
No, no, no.
I mean,
We can share.
I mean, very generally, character evidence is not allowed in American courts because the idea is that whether you committed a crime or committed a civil infraction should not be based on whether everybody thinks you're a really nice person. Because good people do bad things and bad people do good things. There are a bunch of different ways that you can try to get around that in criminal trials. Bibi, you tell me if I'm missing anything, because you as a clerk have actually done criminal cases, which I've never done. The most common one is MO, right? So like every time this person, kills a woman, he does it like this, right? Because that's showing a pattern of behavior. But I don't know why we all think that. Maybe it's from TV or movies or something, but like it is 99.9% of the time, you cannot bring in evidence to show what a nice person someone is. And if you have evidence that they engaged in behavior that you're like, this is a pattern, it has got to be damn near identical. Like, he said these same words to me in this same context about this same, like, and even that I'm not sure would make it. So this declaration, in terms of the actual merits of the case, does nothing.
You can kick the door down. So Justin Baldoni, if you're out there, you don't want to say something on the stand like, I've never verbally abused someone on set, right? Because then you've kicked the door down and they can say, ooh, now we get to call Claire and point out what a big fat liar he is.
That's a good point. Yep.
Right?
Because
So
it
there
can come
are
in. Yep.
exceptions to almost every piece of evidence. All the rules of evidence have these little niche exceptions, and character evidence is one, where if you start testifying about what a great person I am and the community thinks I'm this upstanding person, now you've kicked the door down for them to contradict that testimony. But for the most part, you can't do that.
Well, and I'll just say too, like, it's not just men. But I don't know about you, little girl attorney, but I see a lot in an employment practice when you go to somebody and you say, like, you've engaged in inappropriate behavior, and like what they'll bring as their evidence is like, but here's all the reviews I've gotten in the past. Here's all the emails I've gotten from my boss telling me what a good job I'm doing. I even one time had a person who was being accused of things similar in this case bring us a birthday card that his daughter had sent him. It's like, look, I'm such a good dad. And it's like, this has nothing to do with anything. But I think people misunderstand because in public it matters a lot. But you're right, he's going to have to stay away. I think that's another reason they're not going to fight it with an affidavit of their own. What are they going to do? Go back and forth with declarations about good, bad, good, bad, good? I mean, that's stupid.
Yeah. And
Agreed.
at the end of the day, I don't think it helps the jury decide, right? And that's why character evidence isn't admissible, because somebody's verbally abusive over here does not make them a harasser in a different way over here, right? And that's why we don't let that in. Now, it could be MO, or it could be like regularly conducted activities. So I always do X, Y, and Z before this, so I wouldn't have done that because I always do. I don't know how you would even get that in this type of case, but it's like, I couldn't have been at the light when that accident happened because that light turns green at 6:07 and I wake up at 6 and brush my teeth every day, and right? So it's like things I do every day to prove that I didn't do the thing that would be at issue in this case, which sounds really crazy, but I don't think it would come in here. Certainly Claire's testimony isn't that, right? So,
well, and I think the rule exists for a really good reason, which is that you can't, Like, imagine all of the times that the person being sued for sexual harassment was like a massive creep who was doing this to people over and over and over again, right? And all they, or being racist or whatever, and all they had to do to beat the case was get a couple of people up there to say they were nice. We wouldn't want that. That's not how the justice system is supposed to work. But it cuts both ways. Right.
Someone asked a while ago, but what do you guys do as practitioners and when you believe a client at the outset and then later find out they're lying? I have an answer for this. I'm curious to see what you guys think. Have you ever had a case where you're like, oh, my client is not being honest about this thing? And how do you handle that?
I have. I've had more of like, I can tell you're not telling me everything, right? Where it's like, you kind of have to leave the conversation and come back and like, I can tell this, right, build that trust and then pull it out. I can only think of one situation where someone out and out lied to me, and I knew that they lied to me because the thing they lied to me about was information I had gotten from a third party that they didn't know I had talked to. And they're like, oh no, I don't have a relationship with that person. And I knew that they did. And so I just let her talk about it. And then I let her sit on it a little bit, thinking it was okay. And then about a week later, I went back and I was like, you and I are going to have a talk. And I just sat her down and said, you have lied to me. And I know that you have lied to me because I got this information from so-and-so. And she folded immediately. And I said, I don't have to I can cut you loose anytime I feel like it. And I will. Don't lie to me ever again, or I will cut you loose. And then she was okay from then on out. But like, there are times when people are like, I can't remember. And you're like, yes, you do. And that's more of like, you got to kind of figure out, do you go around them? Do you get emails? But that's the only time I've ever had where someone just looked straight in my face and lied to me.
Yeah.
It happens. I mean, I think when a manager, well, when like I've had situations where a specific manager is being sued for as SH. Where TikTok has totally converted how I talk about these claims, by the way. I used to never say SH, and like,
I say unalive in my regular life, and then I'm like, wait, I can say this out loud. Yeah.
I said this to someone, and then they're like, "What are you talking about?" I'm like, TikTok has destroyed my vocabulary. But anyway, I get why we do it. But so, like, I've had a situation where a manager or a employee is personally named in a sexual harassment case, and they're freaked out. Like, especially with, so most cases are hostile work environment cases where the claim is that you did all these things, all these little things that added up to creating an environment that was hostile to me based off of my protected category, usually based off of gender. And so, people get really, really defensive when you tell them you're being sued for sexual harassment. They're just like, whoa, I didn't touch anybody. I didn't do anything. Like, what are you talking about? And they suddenly review their whole history with that person in this lens of like, I didn't mean it that I didn't do anything. I didn't do anything bad. And the assumption is touching and whatever, the stuff that you classically think of as harassment, sexual harassment. And so I've had a situation where someone is being accused of this, and I'm like, well, what do your text messages say? Like, what did you actually say these words? Like, and they want to paint the narrative to you to make them look better to you. This is like as their lawyer, right? They want you to see them in a good light because they're being attacked. Their character is being attacked and they're being accused of this terrible thing. And so I haven't actually had a situation like not actually golden where someone was like flat out lying to me. I've had people be squirrely about facts and not tell me the whole picture because they didn't want to kind of believe that it could be perceived in a bad way. And so that takes a lot of tussling out like, no, 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 that's not how this works. Like, I'm your lawyer. I need to know everything. I need to know the good, the bad, the ugly, the ugliest, the ugliest. And like, you need to say everything to me so that I can properly defend you. But if I don't know the truth, then I can't properly defend you. And in every single deposition prep and witness type situation, I've told them you have to be 100% honest. I do not want to get into a situation where I have to defend you for having lied under oath. Never do that. And so if I were to find out that someone lied somewhere along the way, I think it's our obligation to make sure that it's corrected in the best way, defending our clients, but we as lawyers cannot present something to a court that we know is a flat out lie. We have a duty of candor to the court, meaning that when we file something with the court, our name is on it. We're saying, Your Honor, this is true to the best of our knowledge. And it's possible that sometimes that changes and we have to rectify that, but like a lawyer does not ever want to be caught in a situation where they have presented something to the court that's a flat out lie.
I guess I can't think of a client story, but as you were talking, little bro attorney, I thought about times when lawyers represented things in a suspicious manner to the court, or they'll do the thing where they'll say, this case, stands for the proposition XYZ, and then you go look up the case and it doesn't quite agree with them. Yeah, but I don't have a direct story on the client thing. I would say, though, that it's really important when you're a lawyer to kind of like walk that line between zealous advocacy and candor to the court. And I'm not, I tend to believe that Blake Lively genuinely believes the allegations that she's making. Like, I don't think that we've crossed that line where her lawyers are aware and she's aware that she's blatantly lying to the court. That's my position. But yeah, I can't think of a story about a client lying.
To really quickly armchair analyze and give my answer, we live in a society that has encouraged this like false binary thinking, and people think of themselves often as good or bad, right? If I did this thing, I must be a bad person, right? And it's very difficult for people to open up, even to somebody in private who can never, unless you admit to like unaliving someone, right? Like, we can't go out and tell your secrets, but even in that context, it's very difficult for people to open up about the things they did wrong. And so I always kind of assume there's more to the story. I don't know that I've had someone outright lie to me. I mean, I'm sure I have, because I always say all my clients are liars. Like, I'm the first person they're going to lie to in this case, right? So I always kind of assume there's more. I always kind of assume that they're going to struggle to tell me the bad things they did or the things they did to contribute to get them to this side. So there's a little bit of like psychology involved in it too. It's not just like, oh, this person is a liar. It's like we struggle to accept and admit out loud the things we've done. And that can be an aspect of how are we going to navigate this case with this particular party with these particular claims.
Can I just say one thing before we leave that topic?
Yeah.
As someone who deals with sexual harassment cases, I will just say, little girl attorney, tell me if it's the same with you. I find it to be a much harder conversation when I have to go to somebody and ask them if they're having a consensual sexual relationship with someone in the workplace. Because a lot of sexual harassment claims arise out of consensual relationships. I know people don't want to believe that, but that's what happens. Somebody gets broken up with and all of a sudden it wasn't consensual. And sometimes that's the truth. They thought it was consensual, and then looking back, they're like, that wasn't consensual at all because that person was my boss. The hardest conversations I've had with clients is when I have to walk into a room of a person I've never met and say, like, tell me for real, are you shtipping the girl who works for you? That's harder than dealing with, with a lie.
It's true.
Yeah.
It's true. It's true. And the point about it coming from previously consensual relationships is so true. Most of these cases happen. And that's why for the companies that I work for and that I advise, have a really, really strict policy in your workplace about relationships, and like don't allow there to be reporting structures or reporting lines in relationships. Like just make that a policy, because oftentimes it starts off cool and then somebody breaks up and then somebody thinks it's consensual and somebody doesn't, and then that's where the problems arise. And it's all within the workplace. It happens a lot. And those conversations are not fun to have, because you have to get into the nitty gritty of things, like how did it play out? What exactly made you think that it was or wasn't consensual? Like nobody wants to talk about that stuff with, especially with a lawyer. Like, who am I? Why do you want to tell me this stuff?
And I have seen the light come on in people's eyes where the person who's being accused genuinely thought it was a consensual relationship. And you sit there and explain, like, do you not see how the uneven power dynamic here was such that this person didn't feel like they could say no? And then they go, oh my God, it literally didn't occur to them. Those are pretty tough moments too, because sometimes you're like, yeah, you were inappropriately using your authority and now you're going to have to pay for it.
Yeah. Yeah. Truth is kind of a funny thing too, right? I mean, truth to who? Because people have their perspective of what's going on, to your point, right? Like, I thought this was consensual. And now looking back, I'm realizing, like, oh, she was just saying yes because she felt she had to, or whatever else. So, your truth is, oh, she was flirty and she liked me. Her truth might be the boss was making moves and read my uncomfortable laughter as flirtation. Truth is sometimes in the eye of the beholder. And then when you get into these cases, people start to open up their purview and go, oh, whoops.
It's crazy to watch happen in real time.
Yeah.
Oh, some people are, I'm just catching glimpses of it in the comments, but some people are talking about the fact that this is a movie set. The workplace is a movie set. And not only a movie set, but a movie set that's dealing with intimacy, is dealing with domestic violence, is dealing with like really, really serious themes, right? And acting out those serious themes, like that adds a layer of complexity over the law that is not typical. I would say it's extremely unique and makes the analysis so much more challenging and difficult, and requires such a much more nuanced look. Because it's one thing to say, like, I work at a Starbucks and I make coffee and someone touched my butt like 3 times or brushed their hands against my back in a couple of ways in 5 days
They
and made
kissed
me
my neck.
uncomfortable.
100%.
It's very different to say that than to say I was literally supposed to kiss this actor, or I had to touch them in this way to film it for this movie. It's a totally different thing. And I think a lot about how when we get to trial, there's going to have to be a lot of explanation for what typically happens in these kinds of sets. And it's a very narrow set of people that can be experts on this, that can say, like, this is how it plays out when we have to film these particular things. And I think the public has extrapolated a lot of things with the allegations that are made to say, like, well, I would never feel comfortable. Well, sure, you're not a actress in a big time theater production. You're not like doing a movie about domestic violence. Like, if it happened in your workplace, it would be wildly inappropriate. We're talking about a totally different case. If it happened to you at Starbucks, then, and I'm sorry, Starbucks, I don't mean to like elect Starbucks on it. But like, it's a totally different thing if it happened at your local coffee shop than for it to happen on the set of a movie that is depicting some of these very things. And so I think that's why, like, adding on the fact that typical hostile work environment cases require a showing of a lot of things, like just a typical one, it would have to be a case like the coffee shop example, where it's like, he did this one time and then he didn't let me take the shift that I wanted when I told him to stop. And then he also like looked at me too long 5 times, and other people noticed. Here are all the witnesses that also felt uncomfortable when he walked really close behind me. Like, you would have to show all of these things in a typical case. Now add the fact that you're going to have to explain how that behavior was different on the set that required some of that type of behavior. So I think it just adds a whole layer of complexity to an employment case that I'm not seeing typically.
Yeah, and we
Somebody,
kind of got a taste of that with the video of the slow dance that was released, and you saw how the different sides tried to frame that. You know, we had Lively side saying like, look at all of this unscripted touching, and we have the other side emphasizing like, well, they're method acting, or they're like leaning into like what the script may not be on the script, but the script says that these are two characters that are deeply in love. Is that outside of the bounds? Because that I think was listed as an incident of SH for Lively. So yeah, I think that's a really good point, and I have no idea because I've never worked on a film before, but I'm so interested to see how this will play out.
And there's your issue of fact.
Right. And I wanted to say this earlier. It's like, okay, I love this word. The word in the case law is scintilla. So like that's like the most smallest amount of evidence that the judge has to find to suggest that, you know, there's some factual issues. And like credibility is also such a big issue in this case. Like I don't know how we get this thrown out at the summary judgment stage, but yeah.
Yeah, you're totally right. The differing interpretations of that dance scene are a fact issue. I think that's why Wayfarer is going for these technical kinds of grounds, right? On the MG, because they know that.
yeah.
But I think one of the things I get frustrated about with this case, and I think Little Girl Attorney, you and I have talked about this as employment lawyers, is there was no sexual harassment for a very long, like there were no laws, right? For a very long time. These things have only been around since the 80s or so. We started defining things this way. And we have done a terrible job as a society helping people understand what that actually means. And in the cases where it isn't obvious, when it isn't quid pro quo, where somebody says, have sex with me or you're fired, I just think that part of the reason, I mean, maybe it's lucky for us because this is why we get to make content and have people watch it. But I just think we as a society have done a terrible job of helping people understand what sexual harassment is, and that it doesn't always have to mean the person's trying to have sex with you. It can mean so many other things. So at least people are finding that out. That's a plus.
The power dynamics. I do a lot of divorce cases. Really, I do anything that'll get me into a courtroom, but I do a lot of divorce cases, and you're so spot on. I mean, the power dynamics of abuse versus sex, I think we don't really understand as a society, and we really fail to talk about that in any meaningful way. So when it comes to DV, when it comes to harassment, when it comes to abuse, we just are starting at zero every single time, it feels like.
I think BB has to go, don't you, BB?
I do. I can hang out for 10 more minutes, but I do have to go. Thank you for reminding me. I've got
I was just going to say, if there's anything that you wanted to make sure you said or anything you wanted to talk about, do it before you have to go.
We'll have you as long as you know, but we know you have to go.
Yeah.
Yeah, I do have to go. This was so lovely. I was a little nervous, but it was fun. This was a lot of fun, and hopefully we do it again soon.
Well, before you go, we've had a lot of questions about Van Zandt. Fierce Crush asked, what's everybody's Roman Empire in this case? And I will ask, why is it Van Zandt? If you want to touch in on that before you go.
I mean, I just hope I get resolution on this. I want to know what happened, when it happened, and who did it. Like what I know now is very curious, is what I'll say. It's very curious.
Yeah.
Maybe in a criminal case, since you've worked on criminal cases, this would just be like a motion in limine to exclude all of those emails and texts, right?
Yeah. And I mean, at least in the federal court system, you can do like motions in limine we did for civil and criminal.
Yeah.
And so, Yeah, so like you would just file a motion before the trial, and both sides would give their arguments on why this should come in and why this shouldn't come in, and so yeah,
But there's no fruit of the poisonous tree in civil cases.
no, no, no,
So
no, no.
it would just be like this information is prejudicial to the jury, which I think is kind of like that's a tough one, like to apply that in the Van Zandt stuff.
You could argue, and I have in a different context, that because there were discovery abuses, that as a sanction, that information should be left out because they abused the discovery process.
Mm,
Now, for my case, it was they document dumped a bunch of stuff after the deadlines. Stuff in that dump was favorable to them, stuff in that dump was harmful to them. And the judge said, you get to use none of it. And we ended up settling. So, but you could make that argument. I don't know if
Yeah.
it's successful.
I think it's also going to depend on what these people said when they were deposed. Because if there's deposition testimony where they just, if Abel and Nathan and these people and Baldoni and all them just admit in their depositions, like these were the conversations we were having, then, it's like now it's in the record anyway. I imagine they were all asked about these things at their deposition. And from what they say out in public, it seems like they were going to explain why they don't look as they appear. But that would be a credibility issue. So that would be a fact issue. I think the thing that makes me so angry about it, other than the fact that someone muted my videos, is that I will never get over that. I will never get over it because I got a copyright violation for the sound of my own voice.
Yeah, not cool.
That's a little transparent. I can see through that. I think it sucks because it really undermines people's faith in the system because it's like, how are they getting away with this? And I'm really empathetic to that. What I really get upset with is when people who do not do what any of us do for a living come on my page and tell me it's a very common practice.
Yeah.
It's just not.
I have yet to speak to an attorney that's not found that peculiar.
Thank you.
Yeah.
I have not met a single person that was like, that's a good way to go about this.
And because this lives rent free in my mind, I'm bringing it up to anyone and everyone. Hey, you're a lawyer. I've got you. Yeah.
All right. Well, I'm gonna dip out. It was so lovely, ladies.
It was so
Bye,
nice
everyone
to
who
meet
sat
you.
for being here. Okay, let's see if I can.
Hey,
think
if
of
you don't know BB, she has a great Substack. You should read it. It's
Thanks,
under
Substack.
same username. You should go read it. She does great writing on there.
Thank
Yeah.
you. Thank you.
So much love for you.
Yeah, the Van Zandt stuff is like I think what bothers me about it too is a kind of like a bigger picture conversation about the justice system, access to the justice system, power dynamics, money. And like I think what bothers me about it is that that's something that's like available to someone willing to spend the money to get it. I feel like everyday people can't get a lawyer to do something like that for them, but a big, powerful, wealthy person can, and and get away with it, right? Like so far there's been no accountability for it, and I personally I haven't done a ton of research on this, but I actually think it's an abuse of process. You have abused the legal process to obtain something for some other reason. And that is the reason why we have this concept. Like, you don't get to take advantage of the legal system for your own personal gain. So, how it plays out in this case, I don't know. I don't think it like is going to cut off all of the evidence from coming in the future for trial. And I also don't know that Wayfarer wants that because their whole MO has been like, here's everything, go look at it. But I think that there is a question mark about whether or not that should be challenged because we had people doing that all over the country, we're talking about our civil liberties, our privacy all being invaded because someone decided to go and just sue and secretly obtain things and behind the back and basically inoculate themselves under the umbrella of law to do so. That's a terrifying reality if everyone was going around doing that.
Yeah, I agree.
Sorry. It's
Jinx, you owe me a
gross.
soda.
I know. Yeah. It's gross. Like it's and the complaint that was filed that started that case is such a load of horseshit, right? It's like we have contracts with people that they violated, but we don't know who they are. Like you have contracts with people and you don't know who they are. I mean, it's so transparently frivolous. But I do think that, again, this is what I don't get with the Stephanie Jones strategy. Like, even if you could say, all right, this was a clever use of whatever, I don't know, even if you could get past the abusive process part, her turning over records when she has a confidentiality clause in her agreement with her client saying she will never do that. I just don't know how anyone would ever tell her anything. I wouldn't tell her my alarm code. I wouldn't tell her anything.
No.
And I don't know, like she's in the business of secrets. So like,
Yeah.
I'm not sure, I'm not a PR professional. Maybe Chris or somebody can figure out what she should have done, but this ain't it.
And I'm always, we all know here that the role of stare decisis and this precedential effect that we have within the law means that everything we do in a case could implicate future cases down the road, right? And so for me, it's not just this case. It's a regular harasser going after a regular workplace who doesn't have the money or access to the lawyers, who isn't going to understand the legal jargon, right? Who maybe would do the same thing and turn over documents because they can't afford to hire a lawyer. I mean, there's so many ways you can see this being used in just really nefarious ways and harming people. And that's always my issue is what are the decisions I'm making in this case? And what's the downstream effect? How does that impact other people? Can I make this argument and turn around and represent somebody else when that argument would be antithetical to them? And that is one of our ethical considerations. Are we making arguments in one case that harms us in another?
Yeah. And I will say
Yeah.
too, like someone brought up the Claire thing again with the recording. Like as an employment lawyer, I'm sure you're having the same, I'm sure we're all having this issue. The law has not at all caught up to the fact that everybody has a video camera in their pocket.
No.
And right, it's like I have that situation all the time where an employee would be like, I'm bringing this claim or oh, by the way, I recorded the whole thing. And we're like, whoa, you can't. But people don't know that just because you can doesn't mean you should, and it doesn't mean it's useful, and it doesn't mean it's believable, and it doesn't mean anybody will, right? So I think technology is moving faster than we can figure out how to advise people that it's usable. And so everyone Sarah said criminals the same thing. Yeah, it's like, just because you can doesn't mean it's going to be the silver bullet. People always think it is, and it very, very rarely is.
It's so true. I had a case recently or a situation, a matter recently where someone, HR was talking to an employee and they found out that they were being recorded because the employee would turn around and send the recording to the manager, like, look, I got you recorded. And they're like, I didn't tell you you could record that meeting. In fact, there's a policy against doing that, but okay, you did it anyways. And then, so every meeting they had with the employee following that, they said, I do not consent to being recorded. And in California, as long as one person doesn't consent, you cannot legally record that person. Meaning that that piece of evidence that you're creating for yourself does nothing, has no legal basis, cannot be used. So that's the other piece of this, like Ayub thing, is like if she recorded him without his consent, my brain is exploding why they would have put it in a record. Who advised her that like this is a good idea? Just say that you were fearful of something and just there's no you are not allowed to rely on that. Now, granted, Ayub is not suing anyone here, as far as I know. So there's no, like, it's not her case, and it's just being provided as an example of something. But it's just not something that a court would use because it was improperly obtained. So, yeah.
Someone asked about an hour ago the amount of motions filed by Lively. Is that normal? And since you guys do employment law, do you think that's normal? I will say from my end, I've seen cases where it's just motion after motion, but not every week. I get big lull points between motions in most of my practice. What do you guys think?
In an employment case, not really.
No.
I've seen it in other cases. I've had like, back in the day when I did more like commercial general litigation and we did like securities fraud cases or real estate development cases or stuff like that. There are cases that get really hot and it's just constant. But in employment cases, I don't know about you, Will, I don't see this. Sometimes around the end of discovery, you do get like a flurry, but not like this.
Why is it
No,
always
I
the
think
real estate cases?
it's always or construction.
Yeah.
I never work. I've seen the construction litigation cases, and that's because they have 20,000 parties and 20,000 lawyers, and it's crazy and goes on for 10 years. I would never. I would gouge my eyes out if I had to do that. But like, well, for employment cases, no, this is unusual. That being said, there's an added layer of complexity to this case that kind of perpetuates more motions. One of which, or two things, one of which is in the control of the parties, one that's not. One is that they have this very onerous protective order and they're marking everything as confidential. And so there's a slew of filings with respect to sealing documents that doesn't typically happen in an employment case because you don't you deal with that kind of outside of the docket, the issues of confidentiality. But because there's all these filings that are happening, they want to attach pieces of things that, since everything seems to be marked as confidential, you have this whole set of things that they have to then either keep sealed or unseal. And that's not something that like typically we see very like the things that would be typically sealed in an employment case like are very like narrow. It's like, oh, this has like the financial account number of someone, or like the very very confidential or highly sensitive trade data, right? For an employer, it's not like, oh, they said something and we're just going to redact it because it's sensitive. This is an overly sensitive redaction case. And then there's the fact that they're bringing every issue to the court. They're not resolving anything outside of court, it seems like. I mean, there might be a ton of fights that they are resolving that we don't know about, but there's a lot that they don't seem to agree on. And they keep beating each other to the punch on things by going to the court and being like, they didn't agree to this, so we're coming to you. And then the other side's like, well, actually, we didn't even get a chance to respond to that email. So, like, they're fighting about things online, in a sense, to, maybe deal with the PR aspect of this case.
Also, that's a really good point. And I keep meaning to say this one day and I never say it. And it's like in my head all the time. One of the things that has slowed things down here is that they both elected at the beginning not to allow a magistrate judge to do discovery motions. When you file a federal court civil case, you sign this initial order and you get to decide, do you want a magistrate judge to do some of the discovery stuff and the stuff that's not dispositive? And a magistrate judge is somebody who sits for I think it's a 7-year term? No, it's a
I think so. I don't
it's
remember.
I get magistrates and bankruptcy judges mixed up about their terms. but this is they're not a Senate confirmed federal judge, but they basically have similar qualifications. And when you use a magistrate judge, they turn and burn stuff because that's all that they're doing, right? I mean, you can even have a magistrate judge try your case if you want to. But when you do that, you send it to the magistrate judge, they make like a recommendation. And then if you don't like the recommendation, you can take that up to the district judge. And a lot of people choose to do that just because it goes faster. Because it's like, if we've all got issues about a deposition or whatever, let's just ask the magistrate because they'll be able to turn that stuff in a couple of days. They decided not to do that here. And that's part of the reason why I don't think Lyman's in any rush. Like, you could have had somebody ruling on what time the deposition starts. But if you're going to make me do it, I'm going to do it when I damn well feel like it. So that was a strategic choice that both sides made. But a lot of cases that I've had in federal court, I don't know about you guys, if it's a good magistrate, we're like, yes, because it'll make stuff move way faster.
Mm-hmm. Yeah. No, the magistrate, by the way, I just looked it up. For full time, it's 8-year term, renewable 8-year term.
Yeah.
So yeah, I mean, magistrates are they're focused too on these issues. So they deal with these discovery disputes all the time, and they like know how to deal with them, usually in a way that's not beneficial only to one side. And so they're really, really good at kind of keeping the wheels moving, as you said. So in my experience, having a magistrate judge deal with this stuff allowed us to only bring to the judge the stuff that we really wanted the judge to see. I think about the fact that, like BB said, that a federal district court judge has whatever number of cases, and they're filing things like emergency, something's going to happen tomorrow at 8 a.m. And he's like, are you so for real? Like I would not want to be the party that's like pissing off the judge, like on something as trivial as that. And so, granted, the judges are not supposed to have their personal feelings about lawyers dictate how they rule on a case, but like I still wouldn't want to get on the judge's bad side because I don't want the judge to look at everything I present to them with a grain of salt. I want them to trust that I'm bringing forward only the things that I really need their like to weigh in on. And so I don't, it's too bad that they didn't trust a magistrate judge to handle that stuff.
Yeah.
You make such a good point too. It's like if you're going to bitch at each other and act like toddlers, do it in front of the magistrate so that when you get to the district judge, you get a little bit of a clean slate. That maybe they're only looking at dispositive motions and stuff, but and I know people want to say like judges are humans too. Like they can apply the law equally and still be like, why are there 5,000 motions? This is very annoying.
Yeah.
And it does matter if I think that's part of the reason the MJOP got pushed back to doing it at the same time as the MSJ, because I think he's like, you guys have had plenty of time to file all kinds of stuff on my docket for weeks and weeks and weeks, but you couldn't find time to file this. And
Yeah.
I'm not going to jump on it just because you decided you wanted to file it today. And I know that's frustrating to people, and I totally get it, but I also kind of get where he's coming from.
And they knew from the outset they weren't going to work well together. Right? I mean, from that first phone call,
That
how
first
this is
hearing.
gonna go. Yeah.
It's not gonna
There's conversations that we don't see as the public, but us lawyers know there were conversations before, right? So from the very moment they denied the extension for the answer to the complaint, the parties knew, right? Like, and even before that, they knew like these guys are not going to give us an inch ever. So it's not like we're now into this and they're like, dang, we should have had the magistrate come in. Like they knew from the beginning. Yeah.
Yeah.
Although sometimes, like, I don't know about you guys, but on big cases where you have multiple lawyers, sometimes there are decent relationships. Like sometimes like an associate on one side and an associate on the other side who are both dealing with the expert reports will end up kind of getting along, and they can sometimes push stuff to get done. I mean, that's the other dynamic in these cases is there's upwards of 10 lawyers on each side that we can see. Then they've got associates and baby lawyers running around researching all of this stuff. And then they've got paralegals and legal assistants helping put everything together. So these are just gigantic teams, and only a few people are actually having the discussions back and forth about these issues. And sometimes those people can be the hardest to deal with.
Yeah.
I also think it's super interesting that Lively has these two firms representing her. Like I never really understood why she has that, like Manat and Wilkie Farr, because because I'm imagining also that they have to parse out the work between these two firms, and how are they navigating who does what and where documents live and who owns which response to what, like that always fascinates me, like that's crazy. Like imagine if the two firms don't agree on a position because they have to agree representing their side as they oppose the other side. I don't know. That's wild.
Was it you? I was just texting. I was working with an attorney he represented the individual, I represented the individual, he represented the company, and we couldn't even agree. And we were on the same side essentially, right? And we had communications where it was basically like knock down, drag out, like our egos getting in the way. And we have the same objective. So you really just never know, personality wise, strategy wise. Like, you're going to get people who are going to get, they're going to have ideas that don't necessarily work. So yeah, I mean, you just never know.
I don't know, like maybe you know better because you guys are on the west side of the country, but you know, Ezra Hudson is the chair of the employment law group at Manat, and Manat is obviously a very reputable and good firm.
Yeah.
I would assume, as the head of employment, I would assume that most of the employment law that people are doing at Manat is defense work, is employer work.
Yeah. Mm-hmm.
And so I sort of was curious from the beginning. I remember the very first day looking her up and being like, oh, this is an institutional defense lawyer. So I get wanting to have an employment lawyer, but then also have these people who are very much plaintiffs lawyers, like Wilkie, because she doesn't think from a plaintiff's lawyer perspective, probably. But I stopped feeling sorry for her when they sent those content creator subpoenas.
Yeah.
Because I know enough to know, because I've worked in a big firm like that, that I would, as somebody who has been on the receiving end of that kind of stuff from plaintiffs' lawyers, I would be like, I'm never doing that. Because I hate it when plaintiffs' lawyers do that stuff to me. So I just found that strange. Like, that's it. She doesn't act in a way I would expect the head of an employment group at a largely employer defense firm to act.
Yeah, I thought about
Yeah.
that too, because their clients are all management side. Like, I think I think they do defense work. That's where the money is. That's how these big firms, that's the economics. So how are their clients feeling about like that's always a consideration for law firms when they have employment groups is, are we defense, or are we going to take plaintiff side work? And sometimes that conflict that can be created, not in the legal sense, but conflict like in people's minds of like, you're coming from this case from the perspective of someone that's trying to take down an employer, like that could cause some tension with existing clients. They're like, hold on, is this like, how are you going to defend me if this is like how you're going to poke holes or teach people how to poke holes through an employer? So it's an interesting pick. I mean, obviously she needed a California employment lawyer because she's bringing California employment cases. Why they chose this firm, why they chose this lawyer, I don't know. Someone pointed out once that Ezra Hudson was like on a board that drafted or was supportive of 47.1. I don't know enough about that. It seems like a lot to like project out that far. Like, we are going to get sued for defamation, so we need the person that drafted this law that protect, like, I don't know, maybe they were cunning enough to do that, but that seems like a lot to calculate.
Correct me if I'm wrong too, but it was Manette,
Manat. Manat.
somebody who worked for them as a law librarian dropped into my comments and they were like, you're not saying it right. And now I can't remember how they said to say it, but it was them that brought Van Zandt as well too, right? So they've been involved from the get. So that's also another interesting point, is like they were the ones who have kind of moved things forward on that end as well.
I'll tell you, if they were my outside counsel, I would be very concerned that they have just told the entire world that you can have secret lawsuits to get the information that you want from the company. That would make me very, very concerned as someone paying them to defend me as an employer, or my clients as an employer. So I don't know why. Maybe they didn't think that it would come out. I don't know how, but that it's just very curious for me what those conversations are in that department right now about this case.
Well, also because if they are representing a lot of institutional clients, like a lot of big firms do, and they're in LA, you would think that production companies and movie studios and people like that would be the kinds of clients they go after. So, if I obviously have never been, the head of a production company, but she is now sort of leaning on the side of actors versus production companies. So I don't know if that hurts their ability to get production company work. Maybe she thinks if she wins, she can sell herself as, you need to hire me because I can tell you what you need to be afraid of, because you need to be afraid of what I did for Blake, because that does happen.
Yeah.
I mean, I suspect there's a little bit of starstruckness too that happens. You know, like I don't know. I don't want to like get too far into speculating about people's personal things, but I just wonder like if they thought, this is easy. This is one of those cases. Like maybe they like because of my original suspicion that they didn't actually intend to file this lawsuit and they didn't intend for it to get this far, that they're like somewhere where they never anticipated to be. They thought like, oh, we're going to be aligned with these powerful, famous people, and we're going to be doing something that it advances or advocates on behalf of women. That's a great look. And that's it. And then, like that's as far as they kind of thought about it and didn't actually conceive that it could actually unravel to the situation that the parties are in now. Like I don't know that if you asked Ezra Hudson, are you happy to be in the situation you're in? That she's like, oh yeah, for sure. Like this is the greatest case ever. I'm so happy to be doing
I
this.
love
I don't. I just
I
don't
love the
think. I just
comments on my LinkedIn. Yeah.
yeah. Like I don't know. I wouldn't. I would be like, why am I here? How do I get out of this? Like.
I'm just putting this out there in case nobody asked the question, but I feel like at some point, first of all, someone asked if Frank is snoring. Yes, he's right here. So if you hear a weird sound, that's Frank. Because you and I, little girl attorney, are the ones who basically brought up the whole independent contractor versus employee issue, and now everybody's losing their shit. At
Oh
some
yeah.
point, we should talk about that.
Yeah.
We should. We should just do it now.
Yeah.
Okay, let's do it now.
How do we approach this? I
Well,
think
why don't you
I may have been
start
responsible for upsetting a lot of people about this.
why don't you start at the nuts and bolts, because I don't know that everybody actually, we're all very smart here, but sometimes people don't really understand the difference between being an independent contractor and an actual employee. So why don't you start there?
Well, okay, let me level set because I think this will make people feel a little bit better. It is not a one size fits all analysis. It's not like we can say, here are the requirements to be an independent contractor, here are the requirements to be an employee. Unfortunately, the
It
way
depends.
federal law is, it depends, and the way that state law is, and like even if you just forget federal law for a second and you only look at California state law, it is so incredibly annoyingly nuanced, the analysis of when someone is an independent contractor and when they're an employee, that you can simultaneously be an employee in one context and an independent contractor in another context. You can also be considered an employee or independent contractor depending on which court you are in and for what purpose it is being analyzed in. So just to level set that, like that's the scheme that we're in, that's the reality that we're in, that makes this so difficult, is that we can't just come outright and say, yeah, for sure, 100% in this scenario or in this whole case that this is what she is, right? So that I want to level set on that. But like when you're talking about whether a law applies, whether FEHA applies, the Fair Employment and Housing Act in California, or Title VII, the federal equivalent to that, when you're talking about the application of those, we can conduct a pretty, common analysis to get to the bottom of whether someone is an independent contractor or not. Not for purposes of like workers comp, not for the purposes of tax, not for the purposes of whatever else, but like when you're talking specifically for FEHA and Title VII, there's like an analysis that we can go through. And I'll stop talking so you're not only hearing my voice, and I'll let Nag do
I like hearing
some.
your voice. I like
I'm like,
when I have little girl attorneys videos on, my husband will literally do a double take, and he's like, "Is that you?" And I'm like, "No," because I think we do have like a similar like tone. I think we talk at the same like sound
Yeah.
space or whatever.
Vibrancy.
Yeah, so I like talking. I like hearing you talk. Something occurred to me this morning as I was thinking about this, and maybe I ought to make a whole video on it. But I think one of the things, and Alicia she finally did the video everyone was begging her to do.
Yeah. Shout
And
out
she
to
did a
her.
great job of saying like tax status is not the same as law applicability. But I think one of the things that helps me like separate it is that when you're talking about equal opportunity laws don't apply to individual people. They apply to businesses. They apply to endeavors, right? So, like, there is no law in the world that prohibits me in my own house from discriminating against Brit in her own house, right? Because the law doesn't apply to individual people. But as soon as I ask for the government's protection by getting a business license, now those laws can attach to me. And so I think the conversation about like, does Title IX apply, I mean, Title VII, or does FEHA apply, is it has to apply to the business that is in operation. And so the question is, obviously there was It Ends With Us movie LLC that was set up. And so the question is, what applied to that business with relationship to the people that worked there? And it's probably a little bit of both. But I've seen a lot of people be really frustrated that, like, so if you're an independent contractor, you just never get protected by the law. And sometimes that's true. But it's not as if everybody's walking around with an anti-discrimination law attached to them. It has to go by and through some kind of commerce, right? Some kind of, this is how laws are made, from constitutions down to legislatures. You have to like opt in by paying state taxes or getting a business license or something like that. And so I just want to make sure people understand that it's not like we're just going to take these people and protect them and take others and throw them out in the trash. It's that this analysis actually gets pretty deep on like what authority legislatures have to make laws and to whom they're allowed to make them apply. Because legislatures are limited in their ability and their jurisdiction over people, right? And so that's what this whole argument is. That's even what the extraterritoriality argument's about, right?
Yeah. Yeah. No, it's annoyingly difficult. It's also annoyingly difficult for lawyers. Like if that makes anybody feel better. We're not sitting here like hiding something from you. I'm trying to tell you that lawyers are when AB5 passed, I was working at a law firm in San Francisco, and I somehow, I don't know why, somehow got chosen to go figure out what this law means. They were like, this is new, you go figure it out. And so I can't even tell you how many hours reading and reading and reading and reading and reading the first version of this when it came out. And there was exceptions and there were exemptions, and exceptions had different tests than exemptions. And you could be exempted from the ABC test, which meant you had to apply a different test. Like, you could never read this thing without your brain exploding. And then everybody was up in arms because they kept amending it, and they still have amended it. And like, I just recently went back to see like what the practice guide has said to say about it, because it's been some years now, and they acknowledge that there's no consistent application of this in a way that is clear for people to understand. And so it's very frustrating for lawyers as well, because it means the difference between whether somebody has rights or not. But we can speak a little bit to the general tenor of the difference between an independent contractor and a worker that does kind of underscore and underline every analysis here. Now, there's, like we just said, there's going to be different applications of the test and different factors, but the general tenor is, have you availed yours? Have you like made yourself kind of beholden to the power and control of an employer in the way that an employee has? Meaning, have you given up certain rights? The right to contract your hourly rate, the right to use your own computer, use your own tools, use your own house, like use your own way, set your own schedule. Have you given up those rights that you have as a business owner, as a person, as an individual worker that's doing the special thing? in such a way that the other person has complete control over it and therefore owes you certain rights and benefits because they have that control over you. That kind of underscores like the whole analysis of whether someone's an independent contractor or worker, I would say across federal and state, like generally speaking. And that's that while there's different tests, that's basically the analysis that a court is going to look into. And like in this setting, we have a situation where a loan out company has made an agreement with a business and is providing services to the business and saying like, these are my terms, this is how much you have to pay me, this is what I will and will not do, this is what you will and will not do, and we're entering into an agreement that like, this is going to happen in the way that we say that's going to happen. All that being said, you go to FIHA and FIHA says actually contractors are also included in the protections,
Yeah.
so it doesn't even matter.
Yeah.
I applaud California for trying to figure out how to deal with gig workers and, Uber drivers and DoorDash drivers and right people who, because employers, in case you guys didn't know, you two know, I mean, in case people who are watching this don't know, the laws in the United States are incredibly employer friendly because businesses lobby Congress, right? So there's very lit, right. So, I appreciate what California was trying to do. It sounds like and I was listening to Alicia's video and she does such a good job of separating it out, that it sounds like what might end up being the case is that whether you're an independent contractor or not, your membership in SAG as a union allows you to access medical benefits, tax benefits, right? Protection by a union representative if you have a dispute, regardless of how you are actually brought on, because it wouldn't be fair if you were an independent contractor, but then they're like, sorry, you're a member of SAG, but because you're an independent contractor, we can't help you or you can't get SAG health insurance, right? So it sounds to me like the union maybe is the connector between, even if you're an independent contractor, you're still a member of a union. And I haven't done a lot of union work. The ones that I have done, I've absolutely hated because all anybody ever does is yell at each other. It's exhausting. I had somebody in a collective bargaining agreement once stand up and point their finger at me and yell at me for 20 straight minutes. And it's just like, what am I doing here? But
I went to school for this.
I know. And you have to just be stone-faced and be like, yes, I am a terrible person. But the point I'm trying to get to is unions don't make laws. Like if unions have rules about how they apply benefits to actors, that doesn't override what little girl attorney was just talking about the actual statutes and law out there about control. It can give a flavor to the situation, but it's not like we don't have to pay attention to independent contractor control because they're in a union. That's not how that works.
Yeah. Yeah, I avoided labor law because it was too stressful. Like sitting in those collective bargaining negotiations, hours and days and weeks. Oh my gosh, too much.
Yeah.
I did it once just so I could say that I did it. And we went through the whole election thing. And some of it was interesting. Like the rules are interesting. But the meetings, the collective bargaining sessions they were just awful. It was just awful. Everyone thinks that everyone else is just the most evil person in the world. But I do believe they can work. If there are some unions that work great and everybody works great together and it's better for the business, but that was not the experience I had.
Yeah.
Do you think Wayfarer will or should file a motion for summary judgment on different grounds than the MJOP? I've been thinking about that a lot.
Yeah, I do. I think that they need to refile their legal arguments with evidence. They can now. Like there's certain things that they couldn't attach with respect to, for example, whether or not she's an employee. and the retaliation claim, the timeliness, all of that, like exhaustion of remedies. They attacked it from a legal perspective, but I think that they can also attack it from a factual evidentiary perspective. I don't think that it would behoove them to file a motion for summary judgment on um, their the FIHA sexual harassment claim because it's going to get denied. Like that to me is like, why bother? Why put all your evidence out there if it's going to get denied? Because the headline will say, Judge, like finds in favor of Lively for sexual harassment. That will be the headline. And they know that that's the result. So I think that there's more that they could do with evidence that they have to support their legal claims so that they can at least see if they can win on those in those two different ways.
Yeah. And the strong argument is, even if the judge doesn't rule on this issue, on the judgment on the pleadings, actually it doesn't survive summary judgment, and here's why, right? Without seeing the evidence, it's kind of hard to know exactly, but I do think that behind the scenes they have some indicia that the retaliation doesn't survive summary judgment. I think that there's strong arguments, because I've been thinking about that too. What would I do if I think the motion for judgment on the pleadings is the strongest case? But I think I would then say, even if the judge doesn't agree, actually this doesn't survive summary judgment, and here's how.
Yeah, like on the California retaliation claim, yeah, I would file some summary judgment because they can show evidence that like there's no causality or it's too attenuated and there's no evidence to suggest that there was retaliate that this thing that you're saying is an adverse employment action is an adverse employment action, and here's all the evidence to support that. Um,
I think there's a strong
yeah,
summary judgment claim for that, for sure.
yeah.
I would just like to point out that I am being bookshelf shamed in the comments because you guys both have color coordinated bookshelves and I don't.
What?
How did they know that I color coordinate my bookshelf?
But they are not color coordinated.
Okay.
Okay.
So,
But it's beautiful still.
Well, see the ones at the top there? Those are like antique ones that came from, I think, like my mom's house or something. And then that other top shelf, I make my husband put all of his stupid, like, Patricia Cornwell books up there that, like, I don't want to read. So that I can put all the I'm very fancy and deep English major books down here.
If you like scrolled into the titles of the books, you will see the books are not that deep. So it's like Crazy Rich Asian trilogy.
I have a combo. I have the books in my living room are color coordinated to match my rug. But the books in my record shelf are all by subject. So I have to keep all the poetry books together, all the here's how to write something books together. So I'm a mixed bag. But
I think it's one of those projects that I'm always like, if I ever have a day where I'm like, I've got to clean this, I got to wipe this shit clean. That's the thing that I will do.
I'm being called out for the Twilight trilogy. Or is it trilogy or no, there's 4. Okay. Can I just say that I did read them all, but I think it was like the 4th book. I was so mad. I've never done this before. I was so mad at the book that I literally took the book and I threw it across.
yeah.
So no hate on whoever the author is. I already forgot their name, but I just couldn't hang by the end. I was like, I stuck with you through this, but I can't hang.
And that's on DNF in the book, right? Did not finish, threw across the room.
I finished it. I just threw it.
Do you guys read anything on like a Kindle or an iPad, or do you read all paper? I read only paper books. I'm
Paper. I can't deal with the little Kindle page. Like, how do I know how much I've read today? I need to calculate. Did I read 50 pages today? Like, I need to do that unnecessary math to know, like.
Yeah. And for nonfiction, I need the ability to highlight it physically because my brain will remember where it was in the book. I've kind of a slightly visual memory. So the like actual physical interaction helps my brain to remember like I read something about this, I highlighted it in this book. I know if I flip through I can find it.
Yeah, like it was on the top right corner of like a
Exactly.
quarter of the way through the book. Yeah, I do that too.
Mine too. Yep.
Yeah.
I
Yeah.
do like an audiobook, like depending on the book.
Oh yeah.
I do like to listen to an audiobook, especially if I'm just like, running around doing stupid shit. But for some reason I just can't.
The
I
Girl
like
with
to
the
hold
Dragon
it.
Tattoo audiobooks were worth a listen because the names, I never could have pronounced all those Swedish names. I would have been just like, this character is letter S and just moved on. That was a really good listen.
Yeah, I've recently gotten my kid. My kid hates to read because he's a 14-year-old boy, but I've gotten him into audiobooks and he likes them much better. And I'm like, it still counts.
Yeah.
It's reading. It's just, as long as you're still like imagining what's happening in your head, it still counts.
It's
Yeah, my
hitting the
brother's into
same parts of the
audiobooks.
brain.
I can't do it. I get too distracted. Like I can listen to podcasts while I'm driving. Maybe I need to try audiobooks when I'm driving, but I cannot like I need to visualize it. I need the words on the page to distract me from thinking of other things. Because if I'm just listening to a story, I can't picture it. I don't know. I don't know how to explain that, but I just cannot do it.
Yeah.
I know what you mean because you're like, well, I'm just got this in the ear, so why don't I scroll on my phone?
Yeah,
Yeah.
exactly.
It's good for a walk or something.
Mm-hmm.
Yeah, that's a good point. Do you guys also, I have like on my, I don't know if you can see this. Oh, it's kind of in the sun. But I have like one, two, three, four, five books that I simultaneously read at the same time.
Yeah.
I can't just like have one book. I have to be like, okay, I'm this far in this book, and then I'm gonna switch over gears and I'm gonna read this other book. I can't like just focus on one book.
Especially like if you like reading nonfiction, you have to have the palate cleanser of the fiction book in between. Because there are nights I'm reading right now, The Bible Says So by Dan McClellan, who's big here on TikTok. And there are times where I'm like, that is not what I can handle after a day of writing motions and briefs and using my brain all day and then being like, let's put more information in. I just read 17 cases at work. So yeah, I need the like Twilight or whatever to.
I'm the same as you, but I read usually one at a time, but I do that exact flip. I read fiction, nonfiction, fiction, nonfiction, fiction, nonfiction because of that exact reason. Like when I read, like I read this book, it's over here somewhere. I read this book called The History of the Middle East, and it was literally about like that entire, like from go, like thousands and thousands of years of Persian history and all that. And it was so good. But as soon as I got done with that, I was like, I got to read something that is so superficial
Yeah.
because I can't, and I couldn't, you're right. I couldn't read that book after work. That was like a weekend book.
Too much. Yeah.
Hmm.
Yeah, for me it's like moods. I'm like, what is my mood today? Can I handle like this like really heavy nonfiction, like it's gonna make me think really hard? Or do I need to like escape into fantasy land and just like read something really light?
Agreed.
Someone asks how we can do what we do all day and then still find time to read and make TikToks. 24 usable hours in every day? I really don't know.
That's it. There's not a whole lot else to life. I'm just kidding.
I don't think a whole hell of a lot about the TikToks I make before I make them, to be honest, most of the time.
Same.
Like, unless I'm making something that's like, I'm going to explain this big concept and I'll jot down notes about it in the morning or something. I usually read it. I give a couple of thoughts. Maybe I make down a note or two and like I make it. It doesn't take that long.
If I have to do something in more than 3 or 4 takes, I always say, you know what, you're not meant to say this. Move on. And then it just lives in
Yeah.
the drafts forever.
Yeah, I also don't make I don't make content about everything, right? Like I'm kind of like keeping track and watching things And if I don't feel like I'm ready to say something about it because it hasn't gelled in my mind yet, then I just won't. And that's why it takes me so long sometimes to post something about a filing, because the minute it comes out and I read it, it doesn't mean I have something thoughtful to say or know immediately how to explain it even. Because I'm like, okay, this thing happened. I have to kind of like think about how it plays into everything. And a partner mentor that I used to work for, and it's stuck with me ever since, is like, you need window time. Like you literally need time to just like stare out into the distance, look outside, and like think about how this like implicates the case. And I still do it to this day with this case, because I'm like, I can give you an immediate gut reaction and explain what it is, but is that even helpful if I'm not like giving you a contextual understanding of what's going on? So I that's why I take my time, like, and I do it when I find the free time. There's been a few times where I'm like, if I don't do this now, like the MJOP ruling or MJOP filing, I saw it late, it was fresh in my mind, and if I don't do this now, I won't do it at all. So I'm just gonna do it now.
I like that phrase, window time. I've never heard that before. I really like that. I
Yes.
usually say I need to marinate,
Yeah.
Mm-hmm.
right? Like let it, it's got to simmer. And then I don't know about you guys, but like when I go to bed at night, I think this is a lot of women in general, but I think as lawyers, because we're dealing with words so much, as I'm trying to fall asleep, there's a period of time there where it's just all, and sometimes good ideas come up during that time. And so it's like, do I get up and write that down? Do I not get up and write that down? But it's all like, it's settling itself down. But usually if that happens when I'm falling asleep, then when I wake up, I'm kind of like, okay, I think I'm ready.
Yeah. I have my side button on my phone set to voice notes for that reason. Is so when I long press that and when I'm falling asleep, I can
Mm.
be like, you should make this argument in your brief.
That's so
Whatever.
smart, Britt. Oh my
Yeah.
God, I'm going to do that.
And then I can sneaky record people. And no, I'm just kidding. Then when I talk to my boss, I'm just recording him in my pocket.
Yeah. I love that. I'm going to do that. That's genius.
It's really nice. I kept a journal next to my bed forever for the same reason. But then you have to wake up and turn on the light and, now you're awake writing stuff down. So
People are asking if any of us have read the book or seen the movie that is the subject of this case. I have done neither.
I have not read the book, but I did watch the movie.
same. I watched the movie.
I haven't watched it. I'm like,
Actually, I watched it with my best friend at a movie theater that like 2 weeks later shut down. And when we went to go see it, the movie theater had been open for like 20 plus years, which was wild. And when we went to go see it, nobody else was in the entire theater. Like there was no one. It was just us two watching this one movie. And then and the poster stayed for ages. The It Ends With Us poster was just kind of like rotting in the sun of this theater that closed down, and it's just like, this is a vibe. Like this kind of like
Funnily enough, I just went to see a Wayfarer movie with that same best friend, I would imagine. So
I
somebody had
haven't seen
asked.
any of the other Wayfarer. I haven't seen any of the other Wayfarer movies, actually. I don't think I have. I haven't seen 5 Feet Apart. I haven't seen Eleanor the Great. I haven't seen any of them.
me neither.
I'm so happy I purchased Nice Indian Boy because I love that movie.
I've heard it's fantastic. I haven't seen it yet, but I've heard it's amazing.
Jonathan Groff is incredible. Zarna Garg, I think you commented on the video. She's so funny. It just was a good Indian Boy. Yeah, it was Nice Indian Boy. Watch the movie. It's one of those movies where you feel good about yourself watching it and you feel okay having an emotional investment in the characters. Because there are times where I watch a movie and I'm like, I really want that brain space back. That was fine. There were some explosions, but like, I could have been reading. I could have been making TikToks.
Could have been talking to you guys on
Oh
live.
no.
Somebody asked if we all met on TikTok.
Yeah.
Like through this because of covering this case. It's wild, but um that's kind of been one of the weird silver linings of all of this for me personally is like meeting really, really cool people that I don't know that I would have otherwise ever have crossed paths with and learning so much from each other. It's been such a cool experience. I mean, I hate to say that when it's at the expense of people suffering through litigation, but like at least for me personally, like being TikTok is new and meeting people online in this way is new, and so it's been really, really cool.
And you've met both of us in person. So
In the
now, not
flesh.
actually golden, we need to meet to seal the circle.
I was just realizing the other day that if I came to LA, I
I
could
know.
meet so many people
Yeah.
because I know you're close and there's so many people in that area. And maybe I'm going to San Francisco at the beginning of November, but that's not close enough. But maybe I need to like pop into LA because that would be a whole smattering of, including the two of you, which would be great.
Do
But
it.
there's a cluster there.
Yeah,
And I
do
do
it.
love LA. I'm a big fan of LA. Everything but, the traffic sucks. But
Yeah.
the weather is a frickin' dream. Oh my
Yeah,
I
gosh.
think the
you can't
last
beat
time I
that.
was in LA actually was for a mock trial competition.
Yeah.
And they always do, the LA competition is always about employment law cases. So that's the last time I think I was in LA. But yeah, other than the traffic, it's a great city to visit. So if you want to come out, Etta and I will drive on over.
I'm a fan. I was telling little girl attorney, my husband he's not going now, but he was thinking about going to a conference in Orange County. And I was like, maybe I can piggyback myself onto this, but no, he's not. He's not
Oh,
going. So,
yeah, I was like, oh, that's a good one. That's a good place. The particular location is
mhm.
gorgeous.
Yeah. Yeah. I have to
Or
go to
or
DC.
we have to do like a TikTok meetup. Like we'll pick a
Yeah.
place, maybe Central America because we're all across the place. That would be fun.
We met up
Like,
in Colombia. Yeah.
Hey, I'm done.
yeah, right. I've got to
Yeah.
go to DC at the end of November, and I'm deciding whether I'm gonna try to meet anybody in DC. I don't know how many people are around that area, but I think a few are. But I have to go. I have to go speak at an employment law conference.
Fun.
And I don't know about y'all, but like when I travel for work, like maybe it's different because I have a kid, but I'm so fucking happy to be by myself. That right, I just bop around like I'm gonna go to dinner by myself. I'm gonna go get a drink because I can do whatever I want, and I
Yeah.
don't have anybody telling me, I'm tired or I want to go home or I don't want to eat that or whatever. So I get pretty jazzed when I travel for work. It's like freedom.
I love
Yeah, I
traveling
try.
alone.
Yeah, I travel. I'm in San Francisco the most is where I spend for work. I travel a lot there, I also lived in that area for a long time, so it feels like going back home in a way. But going like somewhere really different, that's fun because you're like, I could just go do anything right now.
Yeah.
I'm in a playground.
Yeah. What kind of food do I want tonight?
It doesn't count because you're not at home. Calories don't count. Nothing counts.
Exactly.
You're not at home. It doesn't count at all. Do you guys travel like for the holidays? Do you travel for like Thanksgiving or Christmas or anything? Or do you just stay where you are?
I used to when I didn't talk to my family, but then I went to therapy and redeveloped those relationships. And now, ugh, no, I'm just kidding. But yeah, I used to travel for the holidays a lot where I'd be like, oops, I'm out of town.
Been there.
Yeah. Yeah.
We go, we go to the Bahamas for Thanksgiving, actually,
Ooh.
because we have a group of friends, like other friends who have kids the same
You
age.
go to the Bahamas for Thanksgiving. Yeah, I'll see you there.
I'll see you there. It's the best because you don't, and then like with whatever family's left, it's like, when we get home, we'll have, we can all get together and have dinner or whatever, but we're gonna go do because also you get that week off of work or school or whatever, and you're like, I don't want to sit around cooking. I want to go lay and have people bring me drinks.
Yeah.
That sounds heavenly.
Yeah.
Usually I would have traveled home to my parents for Thanksgiving. This year I might be international because I have a friend getting married the week of Thanksgiving, so I
Ooh.
might skip Thanksgiving and be at a wedding in Asia. So,
That.
Oh, um, somebody has been asking, and I keep forgetting, Kenz's request for sanctions. If we could give some comments on that. A couple people were asking quite a bit ago, and I forgot to sound it out. Sanctions, I think people, to start off, people think of sanctions as just the court imposing some punishment, which is usually true, but it's typically grounded in something, right? So, my experience of sanctions, and maybe you guys have different experiences, you're asking for some sort of punishment for like attorney's fees back, right? Or you're asking for fees and costs, how much it costs to bring this motion. Um, so I don't know what the sanctions would look like on Kenz's motion, but do you guys want to weigh in on that?
well, I think we said earlier that sanctions are not going to be looked at until the very end of this case, most likely. Like the judge is not going to prioritize those motions um before these bigger dispositive motions. I think maybe once he rules on the dispositive motions, at some point he'll get to the sanctioned motions. But specifically with respect to that motion, well, you have to go back and talk about what is it referring to. It's referring to the third party subpoenas to Google, YouTube, whatever, which implicated all these content creators. But I think the legal issue is that the subpoenas were directed at the third parties, and the content creators were third party to the third party in a sense, right? So they were not directly subpoenaed. Their information was requested, but they weren't directly subpoenaed. And so I don't know exactly how that's going to play out with respect to seeking some kind of um fees for having to respond to that, because technically they didn't have to respond to that. It was the responsibility of like YouTube, Google, and the other third parties to respond to that subpoena. So that's just a little bit of a nuance that complicates asking for sanctions with respect to that, I think.
Yeah, and I think she had asked. I think they had all kind of asked for, don't let them send these things anymore without giving us, giving the court a heads up. I want a protective order against these things, and I think those things are now moot because discovery is over. And just so people know, like when you go after attorney's fees, whether it's a sanction or not, it's not like you give them a number and they write you a check. You then have to produce all of your bills that you paid for your attorney's fees, which you have to redact so that they can't see all of your legal strategy. And then they get to argue that the fees aren't reasonable and that the attorneys either charged you too high of a rate or charged you too much for that work. And it becomes its own litigation.
Yeah.
So it's not as simple as saying, like, yeah, you can have attorney's fees, tell them how much you want, which is why I think it's unlikely that unless it's a really, really big issue, the judge is liable to do that. I mean, I've had cases where the attorney's fees litigation after the trial for the prevailing party took longer than the trial
Yeah.
Yeah.
because that's a whole thing, right?
Yeah.
I bet you deal with that all the time in divorces, right, Britt?
Oh my God.
With the
I,
affidavits and the experts and the, oh, jeez.
yeah, it just going through your bills and going through with like a fine tooth comb of everything you've billed for, redacting. It's annoying. It's annoying work. I mean, it's worth it because you got awarded fees, but now you're justifying those fees. There's a response to what you file. Yeah, we do that a lot. Probate too. We get some of that. So,
I think
uh,
people are viewing the word sanctions as a punishment, as like
yes.
a wrist slap, an admonition. And while it can feel that way because you're having to pay the other side's fees, that's not exactly how the law conceives it. The law is like you didn't have to spend the money on, you shouldn't have had to spend the money to defend this motion or bring this thing. And so because of that, the law is saying, okay, because you shouldn't have had to waste your resources to do that, we're going to essentially reimburse you from the other side, because you had to do that. Now, in like the situation of the content creators, like unless they went and spent a significant amount of money, there's no like actual sort of equivalent of that. So if they hired an attorney that spent $10,000 to file a motion for a protective order, and like I'm using 10,000 as just a random number, but the point is that if they were put out in some way, then that would be what the sanctions would be recovering, is what they were put out monetarily for having to have brought that motion. Does that make sense?
Yeah,
I mean, it does to me.
it does to me.
Got it. Yeah.
All you people.
Sometimes, like when you're settling a case this big, too. I mean, I'm not saying they're settling, but if there's discussions going on, that becomes part of the settlement discussions. Is like, I'll pay you X amount of dollars and I'll pay your fees, right? Because it's always in the mix. And by the way, I know there were all these like blind items. I don't know how much I believe those, as much as I like watching them, that Ryan's not paying the bills or whatever. And I don't know that. I have no clue. But clients push back on the bills all the time.
Oh, yeah.
Clients read bills, and sometimes, like if you're in-house counsel, you're the one pushing back on the bills and being like, why did it take 8 hours to draft a one-page motion? I'm not paying for that. Why am I paying for 4 people to be in the same meeting times 4? I'm not paying for that. So it's not, I mean, it could be, but I seriously doubt. It's as if on either side of this, they're just sending invoices every month and they're getting wire transfers back. That can also bleed into the strategy conversation. Is like, you know, if you want to do this balls to the wall strategy, don't come complaining to me when it costs $500,000 a month for me to do that. So who knows what those conversations are. I do feel pretty comfortable, don't you guys, that defenses are never on a contingency, but I don't think Blake's lawyers are on a contingency. I think they're
No.
Oh,
It's
yeah.
got to be hourly. There's no way. Whether or not they're getting paid or not, we'll not know. We won't know that. But for sure, there are bills that are going on an hourly basis to both sides.
It's one of those conversations that like always seems crazy to non-lawyers, that some people just don't pay. Like my husband in particular, because he does like bank work and bankruptcy work, sometimes they'll have cases that go on for a very long time, and the client will owe him 250 grand, and they're just like, no, we're not going to pay it. And then you have to sue your own client
Yeah.
to get the fees. But there are plenty of people who will hire lawyers. I mean, that's why lawyers get retainers. But there are plenty of people who will hire lawyers and then refuse to pay them. It happens
Yeah.
way more often than you think.
It happens a lot, actually. And not even just from like, we're not talking about like small time people. We're talking about reputable giant companies that are like, no. And some of that has to do with what they're willing to pay for, and they'll fight you on that. They're like, I don't think you should have had 2 associates on that call. Like, I don't think you should have researched that issue for that long. Or, you know, why did you spend time looking at this document? Like, they will nitpick on things and they just won't pay it. And so there's a lot of fighting that goes on between lawyers and their own clients about what can and cannot be billed. So
And the
it's
bills,
crazy.
you know, it looks different for everybody, apparently, because I worked for, anyway, I've had some people that have had some crazy billing practices. But yeah, you send your clients the bills every month and there's a breakdown. So it'll be, you bill every 6 minutes. So if you spend under 6 minutes, it's a 0.1. If you spend over 6 minutes, it's a 0.2, and so on and so forth. And so you bill in increments of 6 minutes, and you'll say, research the issue of a Liz Pendens on, or something probably easier, like research the issue of property division when somebody signs a disclaimer deed in preparation for filing this motion, right? So you kind of give them what you did, the basis of what you did, who you sent it to for review. Like you get the bill itself is your justification for the time.
Right.
And so you almost are doing a little bit of marketing yourself in your own billing.
Yeah, it's
And
true. Go ahead.
And that's why you're redacting some of that stuff, because you'll say telephone call with the client to discuss strategy of filing motion for judgment on the pleadings and how that will affect their PR. And, some of that you're going to want to redact out because it'd be privileged and you don't want to waive your privilege through disclosing those bills.
People are asking a lot about like who does it. So it depends on the size of firm that you're in or the institution that you're in. If you're in a firm other than a small, if these firms are bigger firms, right? Even Friedman's office is a decent. So they will have an accounting department. And lawyers, I hope Britt was just explaining it, but lawyers and firms literally all day long, you have a pad of paper next to you or you do it on your phone and you're literally writing down point 2, talk to Britt. Point 3, email to little girl attorney about motion to dismiss. Like you do that all day long. And then you put it into some kind of system or an assistant does. And then the accounting department multiplies that by your rate and sends the invoices out. And then typically if there's pushback in a decent sized firm like these, the accounting department is going to be the one who hunts you down and says, excuse me, why haven't you paid your bills? If it gets really bad, an attorney can say, I'm not doing any more work until you get up to date.
Yeah.
It happens.
That happens.
Pay me by this date. I'm not touching your case until it happens. And if you don't pay me by this date, I'm withdrawing.
Mm-hmm.
One time I worked on a case that was like just about to go to trial, and it was a little bit complicated because we were representing the indemnified employees, so the individuals. And when it was because of the indemnity, there was an insurance carrier that was paying for the defense of the individual separate from the employer. And we weren't getting paid by the insurance carrier to represent these individuals. And it got to the point where the person that I was working for was like told them like we're not to the insurance carrier like we're not going to proceed representing these individuals if we don't get paid. And it actually can like really put a stress on the litigation because if you just suddenly walk away from the case, which you're entitled to do if you're not getting paid, it suddenly could really, really, really devastate like the flow of things for parties. So it does come into play more than people think it does, and it can be a leveraging chip. I mean, obviously you can't abuse that either, but like if you're not getting paid, you don't need to be doing the work, and that can be a problem.
Yeah, insurance companies, that's a whole other thing because then they get to decide what the hourly rate is. They get to decide how much you're going to spend on stuff. They get to decide how much you're going to settle for. If they're providing the money, they get a lot of control. So then when you're having strategy meetings, you've got even more people in the mix. People who do insurance defense, they have to deal with that every single day, all day long.
Yeah.
Someone asked earlier, with the indemnification of Jen Abel, does Stephanie Jones have the opportunity now to decide who her representation is? It seems like we're a little late for that. And
I think it's too late for that.
The two.
Because they're adversaries, I think there would be a fair argument for Abel to say, you don't get to choose my representation because you're suing me. And like, I have representation. It's the same representation that is representing me in the claims that you have against me. And that is reasonable. So I don't know that that's worth a fight for Jones, quite honestly, like to try and do that.
Yeah, if you don't follow Risky Business with a Z, you should. She's an insurance adjuster expert, and she does videos where I cannot read an insurance policy. It makes me want to stab myself in the eye. But she does it and she likes it, and she will like go through what some of this stuff means.
I did one insurance malpractice case. One. And I was like,
that's the one.
You're sending this to somebody else. I can't.
The policy language is insane.
It's crazy. Yeah.
I just couldn't deal with insurance companies that all day long. I would just die. I would perish.
It was the one time where I was like, maybe I do like plaintiff work.
Right?
Yeah, exactly. I was
There's
at a conference recently and someone stood up and they were like, it was a professional, it was a legal conference, and someone was like, I make a living suing insurance companies. And literally the entire room of 1,000 people.
Yeah.
Uh,
it's yeah. Oh, you write the God bless you.
God
I
bless
don't
you.
know. It's like a little map because it's like, okay, there's this, and then I have to go back and see what that defined term is, and then it's the definitions and the whole. Ugh,
Yeah.
ugh. No, thank you.
Yeah. I'm calling you if I ever have an insurance question.
No, I'll cry. I'll start crying.
No, Bella Beck.
Oh,
That's what I'm
Bella.
calling.
Okay, don't call me because
Yeah, no.
Yeah.
You'll hang up on me. I'll be like, Mag, I have an insurance question. Hello?
Hello. Who is this?
Who dis?
I don't know who this is. I don't know who this is. All right, we should probably wrap
This
it up.
was fun.
That
Yeah.
was fun.
Thank you, Britt,
You're
for
amazing.
hosting us.
Yeah.
Yeah.
I just want to say to both of you, I have learned so much from both of you, from your content. I love the way you explain things. I love the calm, here's what's going on, the way you approach these issues. It's truly a gift. And I know, teaching this stuff and coming online and taking the time, it's fun for us, but I also know that you're sharing something that you could charge hundreds of dollars to share. So I'm always grateful. And I'm also grateful just to have met both of you. You're incredible women, and I look up to both of you.
That's so generous. Thank you.
Yeah. And I know chat feels the same. They were really saying thank you for all this. So if you guys weren't able to see that, the chat was really
Heart
just-
to chat.
yeah. Shout out chat. But this was a good time, and I'm glad I got to be a part of it. So
I'm just so glad that, like, isn't it funny how we find each other? Like, I never thought I would post a TikTok. I had been just lurking around there for years, like looking, and I just that one day I got like a wild hair, and like I'm so glad I did for a lot of reasons, not the least of which is meeting you guys. Like,
yeah.
Yeah, same.
it's so nice, especially right now where it can feel like everything's all over the place, and I'm constantly concerned about, am I too online? Like, am I touching enough grass and all that kind of stuff? But I feel like we have a pretty good group of like real people. We're not going too down into the weeds.
Yeah, we're gonna make it.
This case will resolve. I mean, I have this ongoing thought of like, what if I wake up tomorrow and they've settled it?
Yeah.
Like, what will we do? We'll do other stuff.
Yeah.
Yeah. There will always be another lawsuit.
Oh yeah.
We know that for us.
Oh yeah. There will be a Drake appeal in the near future. So
Oh my!
That's my next deep dive. I have to read that because it just.
do it.
I saw the first couple of pages and I was like, I need more context. I need more. I need to read the filings.
In my mind, they sat in that judge's chambers at SDNY and made her listen to those songs, and that just makes me so happy.
He's like, well, I get to take judicial notice of this, so play Not Like Us one more time.
Right? Just
What did you
Public
say
domain.
before?
what's that beat again? Yeah, I had somebody on YouTube get really nasty with me about, you don't understand the context of this. You don't understand the culture. And I was like, sit down. Sit down. I went to high school in the 80s and 90s. I have seen more rap battles than you have seen. I can tell you. I'm very well aware.
Yeah. And more than that, the First Amendment implications are really what drew me in, because that's my little niche area of law that I love to follow is, the overlap of art and the First Amendment is always a fascinating question, and copyright and the First Amendment is always a fascinating question.
It's so important right now that we keep our eye on the ball about, any chipping away at the First Amendment really scares me.
Yeah.
Yeah.
Agreed.
You know, we can disagree and people can say horrible shit as long as, you know, I want it to still be there. Because if that one doesn't work, none of it works. They're all kind
Yeah.
of on that.
Well,
Yeah.
thank you everyone for joining us and sticking
Thank
around
you
for as long
guys.
as you did. And for both of you, I loved it. This was so much fun. What a cool way to spend a Sunday.
Yeah.
Well,
And
you
I'll
guys
see.
have more Sunday left than me. I'm going to go eat dinner.
Yeah.
That's true.
I'm
Just
on the
gonna go
eats.
find some lunch.
Well, I
Thank
will
you
see you
both.
both in LA.
Thank you.
Yes, soon, I
Yes,
hope.
we will plan it. We will plan it. And I'm going to go color code my bookcase so that I don't feel left.
All right.
All right.
Report
Bye,
back.
Bye, everybody.
Bye.
Bye.